Senate Committee Room, A305. This is the Senate of Virginia, Richmond, Virginia. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, A305. Did you know that you can watch the Senate live on YouTube? Visit the channel by browsing to youtube.com/@Senate of Virginia. That's youtube.com/@Senate of Virginia. Senate Committee Room, A305. This is the Senate of Virginia, Richmond, Virginia. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, A305. Did you know that you can watch the Senate live on YouTube? Visit the channel by browsing to youtube.com/.
Okay, I'd like to call the Courts of Justice meeting to order briefly. MJ, can you call the roll? I think everybody's here, MJ.
Mr. Chair, you have a quorum.
Okay, thank you, MJ. Ladies and gentlemen, we're going to go at ease for a bit. We did that so some people could proxy in to get up to a resources meeting. We're going to wait till we get a couple more people here to get going. But we're going to go at ease.
The Senate of Virginia, Richmond, Virginia. Senate Committee Room, A305. Did you know that you can watch the Senate live on YouTube? Visit the channel by browsing to youtube.com/@Senate of Virginia. That's youtube.com/@Senate of Virginia. Senate Committee Room, A305. This is the Senate of Virginia, Richmond, Virginia. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, A305. Did you know that you can watch the Senate live on YouTube? Visit the channel by browsing to youtube.com/@Senate of Virginia. That's youtube.com/@Senate of Virginia. Senate Committee Room, A305. This is the Senate of Virginia, Richmond, Virginia.
we have a lot of bills to get through. Right now, we have 61 bills left for two committees, two committee meetings, and we have to move. So that's why I trying to hurry people along. It's not to try to deprive people of a moment or anything, but I'm just trying to cut to the chase and focus on what's important. So having said that, I want to take up a couple of things at the beginning. First of all, Senator Obenshain has asked that we strike Senate Bill 1295. Senator Stewart moves. Stanley seconds that we strike that bill. Clerk will open the roll when you get to it. Yep, 1295.
Senator Perry?
She's in.
Oh. Ayes 14, no zero.
Great. Secondly, Senator Cipher has asked that we strike Senate Bill 1466. Senator Obenshain moves. Stewart seconds that we strike it. Clerk will open the roll.
Ayes 14, no zero.
Great, thanks. The other thing sorry about that. The other thing I forgot to mention is I'd like to take up bills that we've seen before first. I think there was one bill, 1.5 bills we've seen before, but I don't see the patrons here. Eben's not here, is he? Doesn't look like it. And neither is D-Steph, is he? I can't see who's behind the podium. Oh, Srinivas. Okay. All right. So, Diggs? Is his identical? It's not. It's almost identical. Not identical. It's not identical. Okay. Okay. Senator Aird's going to take over while I present the ceiling bill. Senate Bill. I think it's 1466.
Please proceed, Mr. Senator, Chairman.
All right, folks, Senate Bill 1466 is a fairly big, complicated bill, revising a big, complicated bill from 4 years ago. The bill is a recommendation of the Crime Commission. And before I get into the merits of it, I just want to say I've talked to the staff of the Crime Commission. They probably put more time this session into bills than they have in years because the amount of effort that was required to get this bill into shape and the amount of stakeholders, parties, stakeholders, members, et cetera, they had to talk to get this thing in a place where I think, I'm not going to say we have peace in the valley, but we're about as close as we'll ever get to having people happy. So if you all remember, in 2021, we passed legislation that created several new processes to seal criminal offenses. At the time, under the current law, which is scheduled to go into effect July 1 of 2025, there are 7 misdemeanors eligible for automatic sealing, and also misdemeanors that do not result in a conviction will be eligible for automatic sealing. There are also other convictions, including Class 5 and 6 felonies, felony, larceny offenses, and misdemeanors that can be sealed via a petition process. The bill before you is designed to fix a series of policy, procedural, and technical amendments to these criminal sealing laws that are currently set to take effect on July 1. What the bill in front of you does, it fixes several problems. Importantly, it ensures that all possession of marijuana charges and convictions will actually be sealed. The way the legislation that's currently on the books works is a marijuana conviction or charge is only sealed if it appears in the CCRE, which is basically like hardly anything, because most people, when they're hit for marijuana, they get charged by summons and they don't get arrested and fingerprinted. Secondly, it makes clear that ancillary matters are to be sealed, including things like if you have a suspended sentence, probation, parole violations, contempt of court violations, failures to appear in bond appeals, those ancillary matters will be sealed with the underlying conviction. The existing law is ambiguous, and so it created the possibility that you end up burning your two chances to seal offenses, sealing bond violations or failures to appear, et cetera. And the law just wasn't clear, so this resolves a big ambiguity in the law. Next, the bill creates a petition process for you to seal offenses that were supposed to be automatically sealed, but for some reason the computer process doesn't pick up the automatic sealing. so that you don't end up burning one of your 2 lifetime sealing things on something that should have been sealed automatically but didn't because of a computer error. Because there's concerns as to whether or not the computer is going to get everything it's supposed to. Next, it repeals the court-appointed attorney provisions for sealing petitions. We discovered it's really complicated to appoint somebody to represent somebody who's sealed when we don't know whether they're eligible to seal when we appoint them. And so trying to create exactly how that court-appointed counsel thing would work was a mess. We decided instead of doing it, we're just going to repeal it because it is way too complicated to resolve. Next, it requires restitution to be paid before somebody can file a sealing petition. I know a lot of people aren't going to be happy about that, but the way the law was written, it created the problem where somebody could seal an infraction or a conviction where they still owed restitution, and it's hard to figure out how you're going to enforce restitution when the underlying conviction is sealed. And so that's something we can come back and revisit in the future, but in the meantime, we thought it was best to say you can't seal something if there's still restitution owed. The vast bulk of these anyway are misdemeanors and very low-level felonies, so the odds of the restitution being really high are probably pretty low. Next, it allows sealed convictions to be used for bond determination and sentencing guidelines. The existing statute, if you read it, probably meant that if you had a sealed conviction, it could not be considered if you violated later, 7-10 years later plus, and it could also, it was not clear, but probably the underlying sealed conviction could not be used in the sentencing guideline, which kind of, it probably ought to be if we sort of, in talking about it, decided that if you got the second chance and you go out and reoffend, it probably ought to be considered that you already had your second chance on that. It also limits the automatic sealing at the conclusion of a misdemeanor case only to acquittals and dismissals, but not null process. That was another thing people had concern about because sometimes cases are null process because of failure of proof or failure of evidence where a witness doesn't show as opposed to an outright dismissal. It also addresses various logistical concerns raised by the Virginia State Police, OES, the circuit court clerks, and the DMV that are necessary to facilitate the July 2025 implementation. And most importantly, which was important to a lot of people, it scopes down the numbers of offenses that are eligible for sealing. It basically, broadly speaking, it excludes sex offenses, violent crimes, protective order violations, things that are domestic violence related, for example, things like stalking, hate crimes, so you can't seal a cross-burning conviction if this bill passes, animal cruelty, I believe child neglect, and offenses related to election crimes. So those are now out, completely ineligible for sealing. The prior law said you could only seal, the only offenses excluded, Class 5 felony down, were DUI and domestic violence. So that's a rough outline of what the bill does. If anybody wants to get into the weeds and the details, we can get into that. Also, I believe Senator McDougall has a bill that needs to be rolled into this, which is the Supreme Court's version of the same thing, Senate Bill 1211. I'll entertain, or I'd hope somebody would make that motion so we could do that.
So moved.
Second.
He didn't ask for it, but basically Senator McDougall put in a sealing bill the Supreme Court requested, which contained only technical amendments, which are all subsumed in my bill. We're not going to pass two bills. We're not going to have two vehicles. So he's either getting rolled or he's getting stricken. But when he comes back, we can undo it if we have to, I guess.
We have a motion that's been moved and properly second. Can we take a vote on that really quickly?
Open the roll. Oh, yeah. Good idea. Madam Chair, there's also a substitute that's already was posted 2 days ago or last night.
We need to adopt the substitute. It's been moved and properly second to adopt the substitute. All in favor?
Aye.
The substitute is properly before us. Mr. Chair, do you have anyone here to speak relative to your bill today?
I'm sure there's a lot of people here to speak. I don't want to offer anybody, but the crime
So
commission's-
we'll make it really quick. Is there anyone who really quickly wants to offer comments regarding the chairman's legislation this morning?
Go 5 and 5.
Any attendees online in support, please raise your hand now.
MJ, go 5 and 5.
We'll allow for 5 minutes on both sides.
Good morning, Chair Sorrevell and members of the subcommittee. My name is Lauren McGarry. I'm an attorney at the Legal Aid Justice Center. We appreciate how much work and collaboration has gone into this legislation. At LAJC, the majority of my work is in expungement representation. The Legal Aid Justice Center has represented hundreds of Virginians who've qualified for expungement expungement when their cases have been dismissed. We worked with this body under the leadership of Chair Suravel in 2021 on that legislation. In the last 4 years, we've conducted information sessions about the upcoming bill and fielded calls from people all across our Commonwealth. I've personally given legal advice to hundreds of Virginians excited about the record sealing for a better future for themselves and their families. Several of them have broken down crying in tears of relief that they will have a future no longer clouded by their past, or they'll get what's called a second chance. Today's legislation changes who will be eligible for a second chance. We are committed to working on this issue with all of you this year and the next, in hopes that the promises in the 2021 legislation can be realized soon for all Virginians that deserve and need a better chance for tomorrow. Thank you.
Thank you. Do we have anyone else in favor of the legislation?
Good morning.
Good morning.
My name is Randy Carter. I'm the clerk of the Circuit Court of the City of Suffolk, and I'm here on behalf of the Virginia Court Clerks Association. And I want to first thank the Crime Commission and the other stakeholders for getting together and working this thing out. We ask that you pass it as it's written. We think it's a good bill. It may need some tweaking later on, but we have a very good start. And to quote the chairman there, it's way better than the one passed in 2021, and I think we need to move forward and adopt this one rather than what we have in place. So I'd ask your favorable consideration, and thank you.
Thank you so much. Anyone else in favor of the legislation? Thank you.
Good morning. Thank you for seeing me, Chair, Honorable Chairs. My name is Mike Berryman. I'm speaking on behalf of the Humanization Project, and we support this bill for ensuring the benefits of record sealing that are felt by thousands of Virginians whose lives are held back by convictions that do not reflect their character of who they are today. The impact of this expungement law was immediately transformative on a systemic scale when it passed. It is one of the best things that the caucus has ever done on justice reform, and we are deeply grateful for everything you have done and the technical fixes necessary this year to guarantee those benefits to everyone will help are deeply appreciated. Thank you very much.
Thank you so much.
If you are online and wish to speak electronically, you must turn your camera on now or you will not be brought into the room. Thank you.
Rob Hogenclass for Justice Forward, Virginia. We strongly support this bill. This is a workforce expansion bill. There's no reason why a person with a criminal record who has kept their record conviction free for 10 years should have to live with the stain of that conviction. This will increase access to employment, will increase access to housing, will give dignity back to people who deserve it, and we strongly support the bill. Thank you.
Thank you. Again, if you are online and you wish to speak, please make sure your camera is turned on.
Adrian, you may now speak. Valerie Slater, you will be next.
Morning, committee. Thank you so much for hearing my testimony. My name is Adrian Rocha. I'm the policy director for the Last Prisoner Project. We're a national nonprofit. Just testifying in strong support of this bill. I'd like to raise a couple issues that don't need to be addressed in this bill, but for further consideration as you continue to streamline the expungement process. One thing to consider is the certificate of completion of expungement for individuals, especially those going through immigration proceedings. Having proof of expungement is tremendously helpful in immigration proceedings. To prove that an expungement has lifted criminal convictions, helps expedite the process. Thank you very much and urge strong support of this bill.
Thank you.
Valerie Slater, you may now speak. Bakura Shabazz, you will be next.
Good morning, Chair, members of the committee, Valerie Slater, Executive Director of Rise for Youth, and the Criminal Justice Chair for the Virginia State Conference and AACP. We both strongly support this bill for the reasons previously stated.
Thank you.
Bakura Shabazz, you may now speak. Bakura Shabazz, you must unmute your microphone.
Thank you so much. Good morning, Chair and members of the committee. My name is Bakura Shabazz, representing the Injustice Reform Network, a nonprofit organization. Good criminal justice bills, and this is one of them, and we are definitely in support of this bill and ask that you pass this bill. Thank you.
Is that the last one? Yes. We'll now welcome anyone in opposition to the bill. We'll now welcome anyone in opposition.
Any attendees online in opposition, please
Welcome
raise your
anyone
hand.
in opposition to the bill. Okay. Anyone online?
Mackenzie, you may now speak.
morning. My name is Mackenzie Babachenko. I'm a Hanover County Commonwealth's attorney. I also want to thank all of the people for putting in a lot of hard work. I did go back and watch the Crime Commission meeting, and I know a lot of kind of big picture issues were resolved during that. I did want to note that I still have some concerns about the list, and I would urge the body to consider expanding the list of exempted charges that can be sealed. I noted that there was peeping that was not exempted. First offense, first offense stalking, that's not domestic violence. I didn't see where that was. Financial exploitation of vulnerable adults, that's deemed larceny, so that would be able to be sealed. And first and second offense, sexual abuse on a 13 to 15-year-old. And then first and second offense, unlawful filming. So I saw that third offense is registration offense on the, which was in there. And then 386.2, I believe, was included in the expanded list of exempted charges. But those were just a few. And I would ask that, and I understand where we are right now, that this is going into effect. I would just ask the body to consider reviewing some more of these charges to make sure that we don't have any charges that are a problem for public safety. Thank you.
Thank you so much. Mr. Chair, did you have a question for the witness?
No, Madam Chair, I would just ask the witness if she has a list, she should send it to me and we'd be happy to look at it. The intent was to pick up all the sex offenses. I couldn't hear what the first one was, but it'd be easier, peeping. I think the easiest thing is just to send a list and be happy to look at it and talk to the Crime Commission staff and the stakeholders to figure it out. The exclusion list is really long, and there's a couple of statutes have big categories of things, and we need to go compare it.
Thank you so much. With no one else left to testify, the appropriate motion would be to...
Really quick.
Oh, okay, you have a question. I'm sorry, I don't have the board. Can't see it. Okay, Senator Peake.
Thank you, Madam Chair. And I'm not going to go into the underlying policy for the 2021 bill, but believe me that I think it was a terrible, terrible policy that we passed in 2021. And to quote the movie star guy from Argo, this is the best option of a very, very bad option. It's the least worst that we can do is to fix many of the terrible things that exist in the 2021 bill. This does fix some of them. It is still a terrible policy. The Crime Commission worked through it. We got as many concessions as we could given the makeup of the Crime Commission and I think the makeup of the General Assembly. This is the best we're going to do with this very, very bad underlying policy. I will be voting for it as a member of the Crime Commission, but there's a long ways to go.
Madam Chairwoman.
Thank you. Thank you so much, Senator Peake. Senator Carol Foy.
Thank you, Madam Chairwoman. Speaking to the bill.
You have the floor.
Thank you, Madam Chairwoman. First, I'd like to thank the stakeholders and the patron for the hours of painstaking work it took to find a compromise in this bill. I understand the reality of the circumstances, but I also understand what compromise means, and I believe that this is a good compromise bill to pass at this juncture. I just would like to go on record for saying that, and again, there's been many amendments, but removing filing fees and service costs from expungement and sealing cases, allow petitioners to include multiple charges on the same expungement petition, allow petitioners to review their criminal history record, information at the hearing, and requiring defense attorneys to represent people when prosecutors object to contemporaneous sealing. So those are just some of the language that I hope that we can continue to work on as we improve this bill. But again, I just want to thank the patron again for this work and the stakeholders as well. And this is a good compromise bill, and I will be supporting, and I hope everyone else will as well.
Thank you so much, Senator Carol Foy. Anyone else in the committee have
Madam
questions
Chair,
or comments?
let's
Yes,
wrap
Mr.
up.
Chair.
I just want to note, just so everybody's aware, that on the Crime Commission, every legislator on the commission, Democrat and Republican, voted yes on this. There was opposition from administration people and Commonwealth attorneys, but all of the legislators voted yes. The bill is a bipartisan compromise. There's no question about that. That was our intention from the beginning in having this conversation. The Crime Commission staff was very helpful in facilitating that. I want to be clear also that in terms of the underlying policy, Virginia, as of today, until July 1 when this law goes into effect, is still one of only 35 states in America that doesn't allow you to seal a felony conviction. We're one of only 7 states in America that doesn't allow you to seal a misdemeanor conviction. The bill, the underlying law requires you to be of good behavior for 7 years for misdemeanor, 10 for a felony, which means, nobody's going to be seeing this if they're 18 until they're 25, if they're 25 till they're 32, if they're 30 till they're 37. It's a long period of time you have to show good behavior. We were very conservative in the thresholds that we set when we passed the law 4 years ago. You only get to do two sealing petitions in your life. So if you have a long rap sheet, you're not going to be able to seal it all. You're going to have to be able to focus on things. So the underlying policy, I think, is strong. The other thing I want to say is that the bill, if you get something sealed, it lifts any barriers to employment. This is the first time, I think, on the books we'll be able to get relief from barrier crimes, which I think is very important, as you heard, in terms of expanding our workforce. And the last thing I just want to say, I just want to really thank our staff for all the work they've put into getting us to here. You all really have no idea how much work they've put into getting this thing in shape, and all the conversations I've had with them over the last 2 years now. And then even before that, just passing the initial bill was a lot of work. So anyway, hope we can pass the bill. We need to send this to finance.
Thank you so much, Mr. Chair. The appropriate motion would be
Go to finance.
move to report and refer to finance. That motion has been made and properly seconded. Can we open the voting board? That bill reports.
Ayes 9, noes 4, abstentions 1.
Thank you, Senator. I appreciate you chairing it for that moment. We don't have Senator McDougal back from Resources yet. He's not going to be back for a while, so I'm going to move to some other bills. Let's see. Is D-Steph here yet? No, he's gone. Okay, Diggs, you have a bill that was similar to a bill you heard last year that you carried, 1108, I believe, right? Okay, why don't we do 1108? Fifth one. There's a 7. Okay.
All right, thank you, Mr. Chairman. This bill was presented last year in a broader sense. However, this year it has been pared down and mirrors exactly what we do in our local parks. And essentially this prohibits registered sex offenders from being within 100 feet of a gym, a playground, athletic field facility, or a gymnasium. So mirrors exactly what we're doing at the locals, and it is within 100 feet, which now allows registered sex offenders to use other parts of a state park, such as trails or scenic overlooks.
Okay, so the members remember this bill last year basically applied, I think, to the entire property of a state park, and one of the concerns raised was that somebody might run into somebody on a hiking trail, not realize there might be children there, might have been into the woods or who knows where. And so you've narrowed this down now to playgrounds, athletic fields, facilities, or gymnasiums, right?
Yes, sir.
That's it. Okay?
Very restricted.
Okay. Is there anybody from the state police here? Sex offender program? Answer a quick question for me. No. Senator, one of the things that one of the questions that got raised with me about this was apparently sex offenders are given a pamphlet of materials from the state police notifying them where they can and can't be. I think they are. I just want to make sure that that material was modified to.
You would think
clarify this.
Do their due diligence and do that, and this only.
I would think so. I just wish they could answer the question, but they don't seem to be here.
And this only would apply to people convicted after July 1st.
Okay, so, Senator, can you do me a favor and check with the state police on that and get me an email from them or something about whether they notify or not if this bill moves along, and then we can amend it if necessary to make enactment clause or something to make clear they're going to add that to the notification materials. Anybody else have any questions for Senator Diggs about this bill which has been narrowed? Anyone? Any questions? Doesn't look like there's any questions. Okay. Okay, why don't we set it at 2 and 2, MJ? Okay, is there anybody in support of the bill? Come on up. Actually, is there anybody opposed to the bill? Anybody online? No? Okay, you got your instructions?
Yes, sir.
Okay, it's been moved and seconded. The bill be reported and referred to finance. Clerk will open the roll.
Senator Stewart?
Thank you.
Ayes 14, no zero.
Diggs, that's all you got, right?
I got one more, 750, sir.
750 is not a finance bill. We really got to focus on finance bills first, okay? But if you want to hang around for 2 or 3 hours,
It's quick, we can do it.
we need to prioritize the finance bills. So, but we can take you up, top of the docket after we do the finance. We have 15 more finance bills to do, so we need to do that. And there are some questions about your bill about whether it's already covered, Senator. So you might want to go try and answer that question while you're out and about. Did I see Eben? Did he leave? He left. Okay, D-Steph. Trying to repeal our work from 2020 again.
That's correct, Mr. Chair.
Okay. 947. Okay, what do you do now here?
And basically, Mr. Chair, what we're trying to do is, we've noticed under the National Highway Traffic Administration that DUIs and DUIs for marijuana have gone from 4.5% to 10 to 12%.
I think you got a sub, right?
Sorry.
Okay, Senator Stewart moves, Peak seconds, the substitute. All those in favor say aye. Aye. Anybody opposed? No, okay.
So the NHTA has stated that DUIs and DUIs for marijuana have doubled since 2020. With the rise in accidents involving drivers under the influence of marijuana, this legislation aims to give law enforcement the necessary tools to protect public safety on our roads. By empowering officers to address clear violations such as defective equipment, expired registrations, bill helps prevent dangerous driving conditions before accidents occur. They have to have reasonable suspicion of odor of marijuana. This provides and closes the gap that currently hinders officers from acting on credible signs of impaired driving and ensures safety on the roads of all Virginians. Balances enforcement with civil liberties. Bill maintains the requirement for a reasonable suspicion so that stops and searches are not arbitrary. Law enforcement will be held to standards that protect both public safety, individual rights, ensure fair treatment of enforcement process. Our officers need clear guidance, and the authority to enforce traffic laws effectively. Restoring these powers allows them to intervene before minor infractions become serious threats and hopefully reducing the number of DUIs on the road. Marijuana legalization and usage has increased since 2020. It's critical to adopt our laws and enforcement practices to reflect the realities of the road.
All right, Senator.
Any questions?
Great. So you're basically trying to repeal what we did in 2020, basically, right?
Pretty much, Mr. Chair.
Okay. Anybody have any questions for Senator D-Steph? Okay. Why don't we set the timer to 2 minutes, MJ? Is there anybody opposed to the bill? Assume there's a few.
Any attendees online opposed to the bill, please raise your hand and turn your cameras on.
Come on up.
We do have some supporters as well.
I'm sure I can get to them too. Come on up. We got to move this meeting, man.
Sir.
Come on. Get on up to the podium. Don't wait there. Get up here. Come on.
Dominic Martin, New Virginia Majority, and we oppose the bill just on the historical disparate impact specifically against black drivers, and then also how this bill punishes poverty for the investigative and the minor traffic infractions. So we hope you oppose the bill.
Thank you. Next up, Justice Ford.
Brad Haywood with Justice Forward, Virginia. Several years ago when this legislation passed, there were concerns or expressed by opponents of the legislation that it would lead to a whole parade of horribles that would happen on the roads of the Commonwealth. None of that has happened. And if it had happened, we would have heard about it. This bill, with this law, what it's doing is reducing racial disparities, and it's allowing police to focus on what really matters, dangerous driving behavior, not pretexts in support of the failed war on drugs. Thank you.
Good morning, Sheba Williams with No Left Turns. I'm also speaking in proxy for Virginia Normal. We oppose the bill. Thank you.
Thanks. Anybody online opposed?
Valerie Slater, you may now speak.
Morning, Valerie Slater with Rise for Youth and Virginia State Conference in AACP. For all the reasons stated, we strongly oppose this bill.
Okay, anybody else? No? Okay, switch to support.
Any attendees online in support that would like to speak, please raise your hands and turn your camera on.
Morning, Mr. Chairman. Bill Carrico with Virginia State Police Association. We support the bill. I'll give an example. I came into work one day right in front of my office, marked as a Virginia State Police Association office that has troopers coming in each and every day. Guy sitting there, high as a kite, smoking marijuana, permeating from the car. If I'd have stood there long enough, I would have been so high I couldn't have gone in the office. So this gives us the tools back to enforce the laws, and I hope you'll support the bill.
Good morning, Mr. Chairman, members of the committee. Elizabeth Hobbs with the Virginia Sheriff's Association. We support the bill.
Anybody else in support? Anybody online? Nobody? Okay, make sure you tell me. Wrap it up.
15 seconds. So last night, I was driving back from Virginia Beach to Richmond with Delegate Knight in my car. We pulled into Richmond. We saw this car literally swerve up, hit the sidewalk, come back down. We saw him do it again, almost hit another car. And guess what? From where we were standing, we could smell marijuana, but we couldn't see if the driver was black, white, orange, green, purple, or yellow. I don't believe that it has anything to do with racial disparity. I believe that it has to do with smelling marijuana and looking at the protocols when somebody's driving erratically. With
Okay.
this, I hope you'll support.
Hold on, we got one in queue. Senator Perry, I think your light went off.
Sure, Mr.
You wanna
Chairman.
speak?
Yes, I would like to speak. I would just point out that if you have someone who's swerving all over the road, you can stop them. That's reasonable articulable suspicion. There's case law that says that you can stop them. They're swerving all over the lanes for DUI, suspicion of driving under the influence. That's already the law, regardless of the odor of marijuana.
Okay. It's been moving Yeah, what's substitute motion? Go. It's been moved and seconded. Bill be PBI. It takes priority. Clerk will open the roll.
Ayes 8, no 6.
Thanks. I think it's that D stuff, right?
One more.
Oh, you do? Hold on one sec.
That's all heroin.
Oh, that's right.
It does have a financial impact, and we.
Hold on a second. Hold on, Senator. Yeah, hold on a second.
And we have a substitute, Mr. Chair.
Okay, yours is very similar to McDougal's.
I've not read McDougal's, but I'm sure they are.
McDougal has a felony homicide bill. Have you talked to him about, we're not passing both if we pass anything. Have you talked to him about what you want?
I can't hear you say that again.
We're not passing both you and McDougal if we pass anything. We're going to only work on one of them. Have you talked to him about whose we should work from?
I will talk to him now. I'll go up.
Why don't you go find him up in resources and come back down and tell us what you'd like to do. And we're going to take his up later, but you all figure out what you want to do.
Got it. Happy to do it, Mr. Chair.
Okay? I'll see you in a minute. Okay. Thank you. Next up is Evan back. No. Okay, no Evan. Is Srinivasan still back there? Yeah, I know. I can't. He was sitting behind the podium. I can't see him. I'm trying to do the complicated stuff first. Okay, so next up I got two committee members in the queue still. So I don't want committee members in the queue. I got Head. No Head. And I got Pillion, who's finance. And I got D-Staff, we just did. I got Durant.
Good morning, Mr. Chairman.
Durant.
Yeah. That will forever. Good morning. So we've got Senate Bill.
Do you have a sub? No sub? No sub, okay.
Sub.
Yep.
Yeah, I checked on that earlier. So this is, makes it a class 3 felony for any person 18 or older who knowingly possess any substance containing a detectable amount of fentanyl, including its derivatives, and the presence of a minor younger than 15 years old. Mr. Chair, members of the committee, this bill protects children from fentanyl exposure by making a crime, and it's modeled after Code Section 18.2-24802, which protects minors from the dangers of methamphetamine. So it's bringing us to compliance in the same vein. Methamphetamine manufacturing is dangerous, but many more children are harmed by fentanyl exposure than from being hurt during the process of manufacturing meth. Sadly, the overdoses are now one of the leading causes of unintentional death amongst children in the United States, according to the American Academy of Pediatrics. Fentanyl is a primary opioid responsible for fatal and non-fatal overdoses, and particularly in the Fairfax Health District in 2022, 86 of the 88 fatal opioid doses involved fentanyl. Today, research shows that opioids are the most common substance contributing to fatal poisonings amongst children age 5 and under, and we've certainly seen some of this happening in my very district, and I think we've had some cases in Spotsylvania that have had some really sad and unfortunate outcomes. So we all know now, unfortunately, that what fentanyl is so powerful that merely touching its residue can kill a small child. And these fatalities in small children and babies, they just can't continue. We can't have this anymore. And anyone responsible from knowingly allowing a child to be present in the same place as fentanyl needs to be held to that same level of accountability as if they were manufacturing meth. So happy to answer any questions.
Senator, how is this not already child neglect?
One more time, sir?
How is this not already child neglect?
Well, we've got child neglect for a lot of different ranges, but this one specifically speaks the same thing as we do with methamphetamine.
Right, but how do we know this is, I'm gonna ask the question again. Why is this not already a crime? Why is it not already child neglect, a crime?
I guess it's probably under case law, but in the same vein that we brought it up to the same code level for methamphetamine. Yeah.
The child neglect's a felony, Senator. Any other questions? Go ahead, Pete.
A question to counsel. So if it is already a crime, what class felony is it?
Child neglect.
But this makes it a class 3 felony, correct? Thank you.
Any other questions? Don't think any questions, okay. Why don't we set it for 2 and 2? Anybody, we can do support after we do the opposition first, huh? What is it? It's a class 4. Class 4 felony for child neglect. Okay, all those opposed, come on up.
Any attendees online that are opposed, please raise your hands and turn your cameras on.
Brad Haywood with Justice Forward, Virginia. Already, possession of fentanyl is punishable by up to 10 years in prison. That's a lot. And somebody who takes fentanyl, those are people, every time they put that in their body, they know they could die. So adding a couple years, 10, 20 years to a punishment when somebody is so addicted to a drug that they are willing to risk their own life to take it, this will do nothing other than make it or take children away from their parents and make this problem, the fentanyl crisis, even worse. So we oppose. Thank you.
Okay, next, anybody else? Anybody online? Okay, 2 online, go ahead when they called.
Bakura Shabazz, please turn your camera on.
Good morning. I am completely, again, representing the Injustice Reform Network, completely against this bill and any type of punitive incarceration for drug use. It doesn't solve the problem. If the goal here is to solve a problem, then let's do that. But throwing incarceration at everything that you all come in contact with is just not the answer. It doesn't work. The data is there to support that it doesn't work. Can we please stop doing that? We are in oppose of this bill and hope that you oppose it as well. Thank you.
Valerie Slater, you may now speak.
Valerie Slater with Rise for Youth and the Virginia State Conference and AACP. For all the reasons previously stated, we also oppose this bill.
Okay, thank you. We're going to close that and start over with supporters coming up. I assume your support.
Any attendees online in support, please raise your hand.
Thank you, Mr. Chair. I'm Ryan Mahaffey, Commonwealth Attorney for Spotsylvania County. I also speak on behalf of the Virginia Association for Commonwealth's Attorney in support of the bill. I believe that there may be some talk about striking the building word. Maybe that allays some of the concerns. But to the question that was posed to the panel, the felony child neglect statute, there's going to be a body of case law that really prohibits using felony child neglect as a charge based merely on the presence of a narcotic in the same building or area of a child. And there's quite a few cases on that point. So we can't use felony child neglect to address the problem. There is a problem with small children, especially babies, overdosing from exposure to fentanyl, and this would prohibit people from knowingly putting babies and small children in the presence of a substance that can kill people in a matter of nanograms.
Hey, Counsel, have you ever had a situation where a baby's been given fentanyl and died and you weren't able to charge them with anything?
Yes. So there was and this was a child fatality. So there was a couple, and the couple was prosecuted for felony homicide. And the person that was in possession of the drugs was prosecuted successfully for felony homicide. The boyfriend, who was not in dominion and control over the substance, just knew the substance was there and was in control of the children, was not able to be prosecuted because of the gap that I was just referencing in the felony child neglect law.
Can be able to prosecute everybody else and convict them.
No, it pops up from time to time where somebody is responsible for the child and they can't be prosecuted. Only the person that is in dominion and control over the substance.
Okay. Okay. Keep the timer going. Anybody else want to testify in support?
Good morning, Chairman. My name is Bethany Harrison. I'm the Commonwealth's attorney for the city of Lynchburg. I'm here on behalf of VACA in support of this bill, and just wanted to give a little
Be quick.
further clarification briefly for the Class 4 felony that's being referenced for child abuse. We would have to prove disfigurement, a fracture, severe burn, laceration, mutilation, maiming, a forced ingestion of a dangerous substance, and life-threatening internal injuries. And this bill instead would allow us to have a Class 3 felony, 5 to 20 years, to prosecute something that you heard some of the challenges. We're talking about giving examples of someone giving the child the substance, but this bill covers it even being around, which we know fentanyl is different. We have police officers who are merely, in my jurisdiction, packaging closed containers who unknowingly overdose on it because such small, minute amounts can make a grown man overdose. So we would ask that you support this bill. Thank you.
Thank you, and thanks for keeping it short. Okay, we're going to close testimony. Are there any other comments? Nope. Okay, is there any motions? It's been moved and seconded. The bill would be reported and referred to finance. Are there any other motions? And moved and seconded, bill be PPI that takes priority. I think this bill probably, it sounds to me like the bill adds on another crime, especially a big crime, a Class 3 felony, which we don't see very often. It's something that's a lot of behavior that's already criminalized. But they'll probably be cleaned up a little bit to capture some of the behavior that's, and not all this extra behavior that's already a crime, from my point of view. But I don't know how the committee feels. Clerk will open the roll.
Ayes 8, no 6.
Okay. Thank you, Senator. Next up, I have, I saw somebody come in here. Marsden walked in, and Mokai's been sitting there, I think. Mokai, you're up. You want to talk about phone threats? And I think you have a sub, right?
I do.
Okay. Stewart moves. Peak seconds, a substitute. All those in favor say aye. Aye. Anybody opposed? Okay. Senator Mokai, first of all, thank you for giving everybody your sub in advance. You listened to what I said on the floor the other day.
You're welcome.
Want to explain your bill, what you're trying to get at. The phone threats statute is something many of us are familiar with. Want to explain what you're trying to do?
Yes, sir. Thank you, Mr. Chairman, members of the committee. Senate Bill 1298 would create a new
Class 6 felony for repeated unwanted harassing, profane, or intimidating phone calls when they can contact one person 50 or more times, or 2 or more family or household members of that person 50 or more times. I have my Commonwealth's attorney from Mecklenburg County here. I met with him and one of my constituents last fall. This comes from a case where someone made my constituent's life and his new wife's life a living hell. I'm going to let him explain it, and I hope my constituent is on the line to testify as well. If you don't mind, this is Alan Nash.
Okay.
Thank you, Senator.
Make it quick.
Good morning, Mr. Chair, members of the committee. Brief background on how we got here. On December 5th of the year 2020, a gentleman by the name of Tim Hill posted an innocuous Facebook post on his own personal Facebook showing that he had just built a home for his new wife, and he received a comment from a person that he went to high school with that they were in a brief relationship for. He had not had any conversations with this person in over 20 years, and she indicated that she was so excited to begin her new life with my victim in this case. Shortly after that, Mr. Hill received a phone call from that individual that was unwanted. Mr. Hill was able to go through and have a brief conversation with her and try to clear up some sort of misunderstanding. At the end of that, my defendant in this case said, well, it's unfortunate that you have that outlook. I hope you enjoy the telephone terrorism you are about to having to endure. Shortly after that, the next day, December 6, 2020, Mr. Hill received 49 unsolicited phone calls, all of which resulted in voicemails where he was repeatedly referred to as a rapist. His family was threatened. His wife's job was threatened, and this continued. The following day, he received a number of voicemails.
Here's what I want to say. What did the voicemail say?
It said repeatedly that you are a rapist and that your family's lives will be destroyed as a result of what you did to me.
Okay, that statement is not covered by this statute. Is that right, counsel? Doesn't have to be a threat of physical harm?
You are correct that it's not covered by the statute.
Right. The way the Court of Appeals has interpreted this statute, it has to be a statement to kill you or to physically harm you. We have a separate statute that has to do with causing a phone to ring repeatedly with the intent to annoy. That's a separate statute than this one. So this bill wouldn't address your situation.
Right. Now, that was just the initial first phone call. This lasted over 6 months where there were physical threats of violent abuse, that she was going to come to Virginia and impose physical threats.
Okay, what I'm trying to get at, though, is we already have a statute that says repeated phone calls with the intent to annoy is a crime, although it doesn't say with a robo-dialer, but it says but causing it to ring is a crime. This statute has to do with making a threat. And so it seems to me what you would have to have in this is you'd have to have a robo-dialer leaving a message, I'm going to kill you 50 or more times, or I'm going to harm you, not I'm going to make your life miserable 50 times. That's First Amendment free speech, although in theory it's picked up by the other statute. So we're kind of mixing up things here. I'm trying to understand why we would want to pollute this one statute with whatever. The statute that you've written here doesn't address what you're describing. It wouldn't even. They
escalated into threats.
Getting up to this.
Okay, but the way it's written, it would have to be a threat every one of the 50 times.
There would have to be a threatening message overlaid in each one of these 50 times over the 48-hour period, which was the nature of one of the robocalls that was enacted. In addition to Mr. Hill, this defendant actually went through and started to engage his wife. This was a period of 6 months. This happened in December of 2021, where she actually filed for her own additional charges. In addition, there was a robocall used to shut down the accounting business of Mr. Hill's father. So it was essentially set up where that phone was ringing repeatedly over and over and over, where that line had to be canceled. The biggest issue that I ran into in this case was that after a phone ping, we were able to determine that this suspect was residing in the state of Florida. 12 misdemeanors were sought over the course of these 6 months, and I met with Mr. Hill. During we arranged with the Virginia State Police to actually try to support extradition. But due to Florida state statute, they would not hold our defendant for any period of time. These 12 misdemeanors are still outstanding today. I pulled the 911 printouts from that just to show that if this conduct isn't expanded and this defendant chose to engage in this conduct again, there would be no fix under the current statutory remedies available. So that is the basis behind what we're trying to do here. This was a case
Okay. So you basically couldn't extradite a guy because it was misdemeanors in Florida would extradite. You want it to be a felony so you can extradite.
It barely, as you know, it is very hard to extradite on a misdemeanor.
I got it.
This creates the ability to do.
I got it. Senator Favola has a question.
I have two questions, actually. So the use of profane, threatening, or indecent language, this is the section you're amending.
By the Court of Appeals, which has held that saying bad words over the phone is not a crime, it's protected by the First Amendment. So we're only dealing with physical threats of harm or threats to kill. That's the only language the appellate courts have applied that the statute actually applies to, even though it's written that way.
To make the statute go a little broader, as I understand it, but it's not sort of written in that way.
I think my read of the statute, Senator, is that they're not trying to capture a broader course of statements. They're trying to capture if you threaten to kill somebody 50 times using a robo-dialer.
Is that
Robo-dial? That just creates a presumption. If you are sending this kind of
right? That's fair.
It creates that.
Yeah.
Well, I have another. Thank you, Mr. Chairman. When I was looking at the stalking statute a year or two ago, we were trying to expand it to pick up some of these, what you would say, robocalls or emails or text messages, because we're sort of in an electronic world. So maybe General Counsel or perhaps the patron can talk to me a little bit about how this would interact with any of the stalking statutes.
If I may, I actually investigated the statute back then. They were looking for a fix for this situation. The issue was knowing that the defendant was in the state of Florida, there was no immediate threat of bodily harm that the magistrate authorized, knowing that there was something in place there. The only other way to get felony at the time would be to get her subject to a protective order, and this type of conduct would continue on past the service of the protective order. You can't serve someone validly with a protective order out of state. That was the first place I tried to go. And indeed, misdemeanor stalking was one of the misdemeanors that we pursued initially.
Okay, any other questions?
One other follow-up question, Mr. Chairman, and can you use what we would say harassment has interpreted by, I guess, the latest decision that the chairman referred to, court decision? Can you interpret that in building a case for a protective order?
Yes, I would say that would be something that would be appropriate in a protective order proceeding.
If you threaten physical harm or create a reasonable apprehension of physical harm, it would be the basis for protective order.
Yes.
Yes. But not just saying, I don't like you, I'm going to make your life miserable. That doesn't count. Okay, why don't we take set of 2 and 2, opposition, come on up.
Brad Haber with Justice Forward, Virginia. Actually, Virginia's stalking law is interpreted by the appellate courts, allows conviction for a Class 1 misdemeanor for incessant calling in circumstances where the person would feel that they were in some type of harm's way. So this is already punishable as a Class 1 misdemeanor. It's pretty clear from case law. So that's all we would, I don't think this really adds anything. So we would oppose the bill. Thank you.
Okay, anybody else opposed? Anybody online? Nobody online. Let's switch to supporters. You already got one supporter. Is anybody else? Do you have anybody else in support, Mulcahy, Senator? Nobody else?
Well, I should have had Tim Hill on the line. Is he not online?
Is Tim Hill online? Doesn't look like it. Okay. All right. So, I mean, it looks to me like we're mixing up section 18.2429 with the existing, with this phone threat statute 427. Any other questions from the committee? Peak, you got all the proxies?
Yeah, move the report.
Okay, Peak moves the report, and somebody over there he's got a proxy for seconds it.
I've got so much power and so little influence.
Story of your life, Peak. Okay, with substitute motion? Okay, substitute motion, PBI, is there a second? It's been seconded, okay. Clerk will open the roll. PBI. Yep. Okay, thank you, Senator. Senator, talk to me offline about it. There might be a way in the future to go after this, but it's going to take a lot more work. Okay. All right, next up, I got a long list of people who aren't here. Oh, Craig's here. She's first on. She's had him on the list. So, Craig. Decreasing probation period criteria for mandatory reduction. It was similar to Senate Bill 80, which passed 40-0 last year. Can you tell us how it's different from Senate Bill 80 that passed 40-0 last year?
Yes, I will. Thank you. First thing is, last year, SB 80 was 3 earning credits, and this year there's going to be 6 earning credits, and we kind of mirrored them after Executive Order number 36. We also heard from DOC about, or someone talked to them about the 3 months to implement the credits, and we changed that to 6 months to implement the credits, just to give them a little bit longer. Other than that, this is just a bill that will allow, probation incentives are the next step to Virginia's efforts to increase public safety and community stability. I do have several people here that would like to speak that we worked with over the interim of this year to put this bill in and try to make it a little bit more plausible for people to vote for.
Okay, Senator, one question we got from the work group is, what is an evidence-based recidivism reducing activity?
I'm going to yield to phone a friend here.
Thank you, Mr. Chair. Sean Winnett, speaking on behalf of Reform Alliance. The place in the bill that you're referring to is, again, part of adopting the executive order evidence-based practices that they use. The Department of Corrections did a lot of work in the last few years with the Office of Transformation in the governor's office to discover what, in fact, were these evidence-based, what these validated data success factors are. In doing so, they identified success factors and brought those into the executive order and coordinated state agencies. We mirrored that language in this because we wanted to be sure that we were grabbing evidence-based, data-driven success factors to provide opportunities and incentives for people to have earning opportunities to reduce their probation time.
Okay. Is there anybody else? Let me put it this way. This bill passed 40-0 last year, pretty close to this. Is there anybody who's opposed to the bill?
Opposed, please raise your hand.
Question or comment?
I was just going to say this, I believe Rehabilitation Social Services saw a version of this bill last year and reported out unanimously. I know that's a different committee, but it's a pretty straightforward bill, and when you are ready for a motion, I'm going to move that we report.
Second.
You can move in second, the bill be reported or referred to finance. Clerk will open the roll.
Senator Server.
Oh, sorry.
Ayes 14, no 0.
Thank you.
Great, thank you, Senator. Okay, Marsden, you're up. To what?
Chairman, 1431.
Okay, Marsden, you got a substitute?
Yes, there is.
Okay, Carol Foy moves, Perry seconds the sub. All those in favor say aye. Aye. Anybody opposed? You also have a line amendment?
I believe the line amendment is online, but basically.
Ms. Fry, is the line amendment online? Hold on.
Judicial officer to judge.
Okay, hold on. Joanne? Fry. Is the line amendment in the package that members have in their hand?
The packet.
Okay, so members on line 13, if you go to the bill, on line 13, you need to strike judicial officer and replace it with judge. Okay, right, Joanne, anything else? Okay. Okay, so Senator, why don't you explain to us what your sub does?
Clarifies the timeline for implementation, because it's upon statewide implementation before we put this into practice. Uses the generic term universal pretrial risk assessment tool instead of naming the specific instrument. Changes judicial officer to judge, clarifies this only applies to individuals who commit a crime that is eligible for pretrial services as outlined in the code. Clarifies that the pretrial risk assessment tool shall not require an interview for completion, and clarifies that the bill only applies in jurisdictions that have pretrial. And essentially what this bill does, the substitute does with the bill is with second violent offenses requires, once the state has implemented this statewide and the tool is ready, that for second violent offenses, the judge would be required to utilize this instrument to help determine whether somebody is eligible for bail. I think it's something we need to take a look at with a second violent offense and put some science into it as opposed to sometimes bail human judgment. My experience with these has been very good. When I was the director of the Department of Juvenile Justice, we put these in for making detention decisions as to who would be detained or not. It drastically reduced our population in detention homes, drastically reduced recidivism, and substituted science for sometimes failed human judgment. That's what the bill does, and take any questions.
So, Senator, a couple things. First of all, our work group looked at this, and they thought that Romanette number 3 was completely redundant because you're saying that people need to look at people's criminal history when it's a second or subsequent violent felony. You already look at somebody's criminal history when you're doing bonds. There's no reason to restate in the statute. You're going to look at some piece of their criminal history when they already have to look at their criminal history. So why do you have in there that you want them to specially look at some piece of their criminal history when they already have to look at it anyway?
Mr. Chairman, I think what that might be in reference to is the fact that if you're making a determination on a risk instrument, you may need to have that information.
Right, but you already have it, so why restate it?
That I guess the folks who suggested this bill felt that necessarily wasn't always the case. If it's redundant, it certainly can be taken out.
Okay, Carol Foy, you want to make that motion? Take out the redundant language?
I have a different motion, but sure.
Okay, so Carol Foy moves, I got that. Carol Foy moves that we strike Romanette number 3 from the bill and move the word "and." Looks like Senator Saleem seconds that. All those in favor, say aye. Aye. Anybody opposed? No. Okay, next question. Here's the other big question, or two big questions folks had. Number one is, if you're going to do these risk assessments, there's a concern that this is going to result in a lot of people being detained without bail because the pretrial services agency is not able to complete the risk assessment at the magistrate level. So you're actually going to result in a lot more people being detained because they don't have the staffing available for people to actually do these things. Do you have any concern this will actually result in more people being detained than otherwise?
There's a FIS on it for local government of
Okay.
Violent second offenses. That's something that we need to be very careful with.
Right, but they already consider that as part of the bond determination, so.
Anyway, I have
all right.
Pretrial.
Okay. Why don't we take testimony on the bill? Why don't we do opponents first? Come on up. 2 and 2.
David again for Justice Ford. Our concerns are those stated by Senator Surivel. It can't be taken for granted that a pretrial services agency can actually complete these in a timely fashion. And unfortunately, this anchors the assessment also to a definition of crimes of violence, which really I think is in dire need of updating, because it encompasses 2 offenses which are most commonly overcharged, which are abduction and robbery. So a lot of times, people who really have a right to bond on those charges are having a harder time getting it because they were overcharged by a magistrate. So it will lead to more people having their bond delayed, and that is a constitutional right. The most important fundamental right is the right to one's liberty and the right to a hearing on one's liberty. So delaying that at all, to the extent this risks that, at the very least, I think a bill like this would require a but for good cause shown language or something like that, but lacking that, we do oppose. Thank you.
Anybody else opposed?
Somebody in
online, let's go.
Mr. Chairman, I would say this, as in all of these risk instruments, judges do have the override.
Right, but you got to get in front of the judge, which often can take a day or two or three. A day, 24 hours?
Valerie Slater, you may now speak.
All right, Perry knows a lot more about this than I do. You have something to say?
I was just going to say, this is my first job out of college working as a pretrial evaluator. And we got up super early in the morning. I got to work super early in the morning to make sure that we had these pretrial risk assessments completed in time for arraignment for the judge to look at. So no one's bond was delayed as a result of it. We had them in time for arraignment. I don't know what the code says about that. I just know that was our practice, and that's what we did. And so if the code doesn't say that, I agree that no pretrial risk assessment should be holding up someone being able to get bond, although I guess I will say if there wasn't one, then the judge could ask for one because they're asking for more information and criminal history, which they are required to, I think, take a look at whenever in making their bond determinations. And usually they get that information through a pretrial risk assessment, at least in jurisdictions that have a pretrial agency. I'm actually not even sure how they do it in jurisdictions that don't have a pretrial agency. But what I'll say, the thing I think that's confusing to me about this bill is that, and I think evidence-based pretrial risk assessments, I agree with the patron in Loudoun County, we use the Juvenile Detention Assessment Instrument, the JDI instrument, and it helps guide and it has helped get a lot of kids out of our jails because it's an evidence-based risk assessment that helps a judge determine what we can do to keep people, if we need to keep someone in for safety or if we can release them and how to go about doing that. I think the idea is to do that, make sure that adults, we have those same tools to make sure that we're not holding people we don't need to hold and we are holding people that create a danger. I think that's what pretrial instruments are supposed to do. My confusion is they are already used. I guess I don't know what it means by implementation of a universal pretrial risk assessment tool. I know that pretrial uses pretrial risk assessments tools. I guess the question I have is, whether, when you say universal, you're suggesting, Mr. Chairman, Senator Marsden, that different jurisdictions use different types of tools and maybe some of them are not evidence-based. Is that fair?
And this particular instrument would not require an interview, which would, speed up the process by which this.
Can I answer, Chairman?
I do have someone here from.
If I could just ask a question, I used to do these interviews and I don't know, I'm not familiar with a pretrial risk assessment tool that does not require an interview because you have to ask questions, like at least I did ask questions like, where have you lived for the past 2 years that are looking at risk of flight, ties to the community? Do you have someone who can verify that is where you live and that that is your work history or you have a safe place to go back home to, those types of questions that are looking about safety in the community and risk of flight. So I'm not sure how one could be completed without an interview.
Go ahead. Yep.
Of the Virginia Community Criminal Justice Association. We're an association of local pretrial probation and community corrections officers. We worked extensively with the patron on the language. Thank him for taking our amendments. And I have a technical expert online who can answer any more specific questions, but I will just say my understanding is that right now 3 jurisdictions in the state are piloting the public safety assessment, which is a pretrial risk assessment tool that does not require an interview. These are tools that DCJS gives to our officers. They train them up on how to use them, and then they are implemented. But it is piloted right now in 3 localities. The reason for the language regarding the interview is because the assessment that's currently being used in all other jurisdictions is the Virginia Pretrial Risk Assessment Instrument, the VPRA, and that does require an interview. So the issue becomes when someone declines an interview, the assessment cannot be completed because they declined the interview. And moving towards the public safety assessment will eliminate this problem.
Okay. Any other questions, Perry? Yeah, Parker, come back up. Parker. Perry.
I guess my question is, I know you said it was piloted in a couple jurisdictions. It's obviously not piloted in other jurisdictions. The way that I read this bill, I don't think it references specifically the tool that you're using. It says Universal Pretrial Risk Assessment Tool, which is not the phrase they use to describe whatever the pilot is. So I'm not quite sure how that would be effectuated. And my other concern is that I would love to see what that tool looks like and what factors they're using that has nothing to do with person's input and where that information comes from.
Mr. Chair, I'll just say, so we are in the process of piloting the program, and I know that people are submitting feedback to DCJS, and they're making adjustments to the tool based on person's feedback.
Parker, here's what I don't understand. The bill, basically, the way it's written, it doesn't become effective until we have statewide implementation. So how are we supposed to know that this has been implemented in 140 jurisdictions? I mean, how does, and then so that the judicial officers know, okay, the city of Norton has now done it. That's the last one. Now we have to do this. That's the way it's written. So how is anybody supposed to figure that out?
Sure, Mr. Chair. I'll just say we proposed that language because we could not, there's no, official time frame for when the entire program will be implemented. And so that was the best we could come up with in terms of effectuating the bill.
Okay.
And I'll just add, we worked with Senator Marks on the language. We did not bring this bill to him.
Okay.
And I have another question, just generally, pretrial risk assessments, at least my experience with them, they are used in every situation where you have someone who is detained, who is going to go for arraignment, so that, again, to help with the determination of bond. And it seems to me this bill basically says that we require the evidence-based universal pretrial risk assessment, which, again, I don't know if that's a different bill, but you guys are rolling back when we would use pretrial risk assessments, because this says when someone's charged with a commission or attempting commission of second or subsequent violent felony. And to me, that doesn't make any sense, because like the JDI instrument that I referenced beforehand, it's used to make sure everyone has the same instrument, the same access to information, that the judge can make the best determination based on the factors. And so I don't know why we would only limit using a tool that I think could be really helpful in making more fair and unbiased bail determinations, why we would limit that only to a specific set of crimes. That certainly is not the law as it stands right now.
Mr. Chairman.
I'm sorry, Senator Mars, and then Carol Foy.
Mr. Chairman, I would love this thing to be available to everybody in all circumstances. My understanding is that we wanted to have a heavy predisposition towards release to the community and not requiring bail, but on the second violent offense, that the stakes are a little higher, the risks are a little higher, and that this is the way to introduce this risk instrument into into this area. I think everybody under any felony charge coming before a court should go through a risk instrument, just like we do very often with juveniles and making a juvenile detention decision. But if you want to make it universal, that would be great with me. But that was my understanding of what the problem was, is that this would be counter to what we're doing right now.
Okay, Senator, but I think what you're hearing from folks is that it sounds like you're onto an issue, but it's not clear whether the system's ready to accept it yet. That's what it sounds like to me, but you got anybody else in support? We haven't done support yet.
Any attendees online in support, please raise your hands now.
Yeah. Oh, I'm sorry. Did two people opposed? Okay, do the opposition. Let's knock them out quick. We didn't burn out all the time yet.
Valerie Slater, you may now speak.
Valerie Slater with the Virginia State Conference in AACP and Rise for Youth. We strongly oppose the bill. Thank you.
Gary Hughes, you may now speak.
What are we doing with this? Can we speak to? No, a letter to crime commission.
Gary.
Okay.
Gary Hughes, you may now speak.
No.
Good morning. My name is Gary Hughes. I'm with the Virginia Community Criminal Justice Association, representing pretrial agencies, the legislative arm. Real quick background. On a crime commission recommendation, the state of Virginia, the Commonwealth of Virginia, is moving towards the public safety assessment. That stems out of crime commission studies from several years ago. Moving to the PSA allows for a pretrial interview or pretrial investigation to be done without an interview, is going to allow essentially 95% or more of individuals facing charges who are detained to have an interview completed once they go before a judge. So within this bill, we worked with the patron on language. We are not set up as a system in the Commonwealth to provide this for the magistrate, so it should be for the judge. And what I would say is that the implementation of the public safety assessment, which is being piloted by 3 jurisdictions at the moment, 3 more joining this year, will eventually result in anybody who is under this specific language receiving a pretrial investigation, as well as all others who are eligible. So there already is a movement moving towards everyone receiving a pretrial investigation with a new tool.
All right, thank you for your testimony. Yeah, Senator. No, I think there's a, yeah.
Can I have a motion? Excuse me, my concern is a few. First, on line 13, I think I worry that the bail for the accused will be delayed because of the shall language on line 13. I also have an issue with Romanet number 3, and I think some judges may interpret this to read a presumption when we've done away with presumptions for bail here in our Commonwealth of Virginia. I do agree, however, with lines 18 through 20. I do believe that every bail hearing, there should be a pretrial risk assessment tool. We need that objectivity so judges and magistrates can be fully armed with evidence-based information to make bail determinations. However, I think this bill needs a lot of work. It doesn't quite get us there if it was just the language to say that bail hearing should not, or pretrial assessment tool shall not require an interview for full completion. I completely agree and accept that, but with everything else, I think it is problematic. So for those reasons, I have a motion to PBI with a letter to the Crime Commission.
Okay, is there anything else you want to say before we wrap it up?
No, Mr. Chairman, I'm just trying to make progress here towards making more scientifically based decisions. They work.
I agree. It sounds like the Crime Commission's already working on this, and we're already working towards this. Just sounds like your bill might be a year or two ahead of its time. So, okay, clerk will open the roll.
Now you know who your friends are.
All right. Now we got up Eben. Eben, you got a bill identical to what we heard last year. I think it was a bill that Carol Foy carried about liability for the firearms industry. Is that right?
Correct. 1450 last year.
Totally identical, right? Okay. Everybody knows what Senator Eben's bill does. Everybody up here except Favola was on the committee. She voted for it on the floor. Everybody on the other side saw it, probably voted against it. Okay, Peak moves and somebody over there seconds. Yeah, you go sub.
Report.
It's been moved and seconded. The bill be reported and referred to Finance by Deeds and Carol Foy. Clerk, open the roll.
Six.
Okay, bill reports.
The committee for not making me read my 3 pages of detailed notes.
You know what? When Eben walks in, we just pass everything. So he doesn't even need to speak. Okay, wow. Nobody else in line, huh? All right, so we go to patrons. Peak, you had something you want to do, right? I think you have one. Oh, you both have. I have 2 finance bills for you. 97 and 98 are both finance. Why don't we do 97? 1397. Possession of firearms, ammunition, stun weapons, explosives by delinquent persons.
Yes, thank you, Mr. Chair, members of the committee. This is an important bill brought about by a Court of Appeals decision December 3rd, 2024.
Can I give you my...
We started getting a lot of calls from Commonwealth's attorneys distressed by the court's decision in Jennings versus Commonwealth. What that court did in Jennings versus Commonwealth was overrule a 23-year-old Court of Appeals precedent. I see you're scrambling. Do you want me to? No. Okay. Well, in the middle of my presentation. Well, this is a good bill, so you don't want it to be this one. So, for 20-plus years, a juvenile who was adjudicated of a violent felony was eligible for felon in possession enhanced sentence. If he was convicted of a felony as an adult, would be eligible for the mandatory 5 years or 2 years, depending on the type of crime. It was well settled in the Commonwealth. in Carter versus Commonwealth from 23 years ago. In fact, that same principle had been approved by the Supreme Court in 2011, which had addressed a similar issue in Preston v. Commonwealth, which all concluded that an adjudication of a juvenile of a violent crime counted. But what happened in this Jennings case is the Court of Appeals said, well, an adjudication is not a conviction, and they refused to impose the enhanced sentence for a felon in possession. This bill makes it very clear that a juvenile is guilty, whether it's adjudicated or not. Now it just says conviction for the juvenile matter. Very straightforward. Bad decision from Court of Appeals. We got to fix it.
Looks like, by the way, is the decision final? It didn't go en banc or get appealed up? No. Okay, Perry, you got a question?
A question for the patron, Mr. Chairman, Senator Peake. The way that I read the statute, and I haven't looked at the Jennings case in at all, but what I'm reading, what I'm understanding from what you're saying is that the way the statute reads is basically if a juvenile who is adjudicated delinquent and has some like different parameters over kidnapping and different things like that, you can still be convicted of possession of a firearm by a convicted felon. It's just the Class 6 felony. What the court in Jennings did not allow was the enhanced 5 years if it's a violent felony or 2 years if it's a non-violent felony. Is that right?
That is what it in Jennings. I'll have someone else clarify, but he had been convicted of a violent felony, was possession and a felon in possession, and they said, well, it didn't say he was adjudicated, not convicted.
Right, Mr. Chairman.
Go ahead, Senator Perry.
Senator Peake, but my point is that you can still be convicted of the Class 6 felony if you have been adjudicated delinquent. That language seems very, very clear to me in this statute, and I'm getting some head nods from some other attorneys. That's my guess in how they read it when I'm looking through the language and where they fell off on. It doesn't say specifically adjudicated delinquent as it relates to these other mandatory minimums that might apply to someone who's adjudicated delinquent as a juvenile, but it still would apply to them being adjudicated delinquent as a juvenile and then possessing a firearm. It just doesn't do the differentiation about whether it was violent, non-violent, outside 10 years, within 10 years, that kind of analysis that allows for those mandatory minimum enhancements. Is that your understanding?
Yeah, I think you're correct, but the law of the Commonwealth is that if you've been adjudicated a violent felon as a juvenile, you are subject to the felon in possession mandatory minimums. And what the Court of Appeals did in Jennings was reverse a 23-year history of violent juveniles who'd been adjudicated of a violent felony no longer being subject to mandatory minimums.
The opinion in this case came down on December 3rd of 2024. It looks like it was appealed to the Supreme Court on January 22nd, so 5 days ago. So it looks like the Attorney General is taking this up to the Supreme Court to see what they think about it.
That just shows how all I am. Thanks to Commonwealth's attorney from Lynchburg who brought this decision to me. But that doesn't mean we can't address it. We don't have to wait for the Supreme Court to fix again a rogue Court of Appeals and reverse them for the umpteenth time. We can fix it and make it clear so the Supreme Court will know what.
No, we don't have to. We often defer to the courts and there's pending litigation, but not always. You're right. Okay, why don't we go 2 and 2? Why don't you come on up? Why don't we do support first? I know there's opposition. Why don't we do support first this time? Come on up.
In support, please raise your hand.
Good morning, Bethany Harrison, Commonwealth's attorney for the city of Lynchburg. Mr. Chairman, I'd asked my senator, Senator Peake, to carry this fix, and what we're trying to address are cases where, in the Jennings case, you had someone who is now an adult. His prior adjudication for a felony was while he was a juvenile. So you're addressing people who are now adults. Or the second class of cases are where you have a juvenile who's been transferred up to be treated as an adult. And I will point out, even with that, the court has the option of not applying mandatory minimums for juveniles transferred up to be treated as adults, and that's under 16.1-272. But as the senator pointed out, this is over 20 years of precedent. The issue that the Court of Appeals specifically took with this holding was the language in statute that prohibits felons from possessing firearms. And so this is just a quick, easy fix.
So, counsel, can you answer this for me? Is this 20 years of precedent, or you're just saying 20 years where nobody had argued to an appellate court before?
There's a case, Carter v. Commonwealth, that was essentially overturned with this ruling, and that is a Court of Appeals case from 2002.
So you're saying there's a 2002 case where they specifically argued whether or not a juvenile adjudicated delinquent of a felony was subject to the violent felon possession of a firearm statute?
I do not have information about what cases have gone forward since then, potentially challenging that exact point.
Okay. What was the name of the 2002 case?
Commonwealth, 38 Virginia Act 116.
Thanks. Okay, sorry, I cut you off. You all done?
Yes, I am. So I'd ask for this committee to support this fix.
Okay, anybody else in support? We got 8 seconds left. Anybody online?
Mr. Chair, I just point out that also Carter, Commonwealth, and then Preston, a Supreme Court case, followed the exact same logic. It turned out it didn't matter in that case, but they wouldn't have gone through the same analysis, and that was Preston v. Commonwealth, which was Virginia Supreme Court 2011. That's 281 Virginia 52, which was following the Carter.
Say it again.
281 Virginia 52.
Okay, thanks.
Following the Carter precedent from 2000, the Court of Appeals precedent from 2002.
Okay, got it. Why don't we switch over to opposition?
Mr. Chair, Rob Hogan-Class for Justice for Virginia. Let's just be clear what we're talking about here. We're talking about the application of the mandatory minimum provisions, not whether someone who was adjudicated delinquent can be convicted as an adult of having possessing a firearm. We're talking about applying the 2 or the 5 year mandatory minimum. That's what's at issue in the Jennings case. And to be clear, the procedural posture in the Jennings case, there was a panel decision where they said, well, we've got to follow Carter, but one of the people in the majority wrote a concurrence saying, this is an issue that we think we probably got wrong, but the full Court of Appeals has to take that up. And then the same judge in the en banc decision wrote the decision overturning the prior decision of the Court of Appeals from 20 years earlier. So they just hadn't revisited that issue. Textually, it's clear. I mean, that's why the senator had to bring the bill today, that they were spot on interpreting the law here. So I don't know why the Supreme Court would reach a different result, and I don't think this body should change the policy that if somebody who was adjudicated delinquent, we don't need to apply the same. We can let judges decide rather than applying a mandatory minimum when they get to be an adult. Thank you.
Okay, anybody else opposed? Anybody online opposed? Okay. Anything else you want to say before we take a motion?
Basic principle of this, members of the committee, is if a violent juvenile is, again, as an adult, has a gun, is he subject to the laws that we have passed, a mandatory minimum of 5 years or 2 years? Senator Stewart moves the bill.
It's about to say I got a bunch of red microphones over here, but not many members on.
Mr. Chair, I'm right here, and I'm going to make a substitute motion to the PBI.
Yeah, substitute motion takes precedence. It's moved to second. The bill be PBI'd. Clerk will open the roll. Okay, looks like your PBI'd, Senator. Maybe we'll see what the Supreme Court does with that. We might not even be necessary to have a bill next year. Senate Bill 1398 is a bill trying to create another mandatory minimum. I see a theme here, right?
We're not trying to create another mandatory minimum, Your Honor. Mr. Chairman, members of the committee. Police officers are already subject to assault and battery. What we're trying to do is add campus police officers to those same groups that are protected. They're undergoing all the campus police are doing everything that law enforcement officers are for the city. Arrests for DUIs, drugs, assaults and batteries, involved in everything that other police officers are, but they do not have the same protections when they are assaulted by anyone who is on that campus. So this would just add campus police officers to that category.
Okay, and we had a similar bill earlier this year with I think it was the VRMC, Virginia Marine Resource Commission, police officers. We actually reported it out of here, and then the Finance Committee killed it. So this basically does the same thing, right?
No, I don't recall that other bill.
It added the VRMC police to the same statute.
Absolutely did the same thing.
Yeah.
From last year.
Oh, earlier this session.
Mr. Chair, yeah, it was exactly the same bill.
Stewart?
I think it was Stewart. It added VMRC, this adds college.
Yeah. It was D-Step, okay. Marine Resources Police.
Police, we have state universities with 20 and 30,000
Yep.
people who deal with murders on
Yep.
campus and guns on campus. I mean, completely different with all of our major state universities.
But guns are on campus. You like that.
I do like that. Yeah, campus stuff.
You've got a bill.
Okay, it's on, Deeds. You got to talk to the chair.
Mr. Chair, I don't like our police officers being assaulted on campus. And if they're assaulted, they're the same protections as regular law enforcement officers.
Okay, so let's, is there anybody in support of the bill? Probably not, right? Probably usual suspects kind of thing. I'm sure you have supporters. I'm not saying there's nobody here, but.
Finance.
Okay. Anybody opposed to the bill? Doesn't look like anybody's opposed. Doesn't look like they think they need to come up. Okay. You got a motion, I guess?
To report.
Obachane moves, Peak seconds to report and refer to finance.
Substitute motion. Pass the bill by indefinitely.
Okay, Deeds moves, Carol Foy, sorry. Deeds moves, Carol Foy seconds to PBI the bill. Clerk will open the roll. It's done.
6.
Okay, we're chugging along here. Salim, why don't we do mail theft? There's complexity on that. We're going to move to Senate Bill 939. Deeds moves, Carol Foy seconds, to substitute. All those in favor say aye. Aye. Anybody opposed? No. Okay, substitutes before you. This is a bill to try to steal from the federal code or steal a federal concept and create a new crime of mail fraud in Virginia so that we can do what the federal government should be doing but won't do, which is probably going to be a common theme for the next 4 years, some of us think. So,
And Madam, Mr. Chair, I was just, that cuts to the chase of it. I wondered why we needed to do this.
Again, it's just, we're trying to make sure the state level crime matches the federal side, given all the check fraud that's been going around lately.
Senator, I think what you're saying is that the federal government will not prosecute a lot of these unless there's a whole lot of mail fraud involved. So if you have individual mail thefts or whatever, it's hard to get the FBI and the U.S. Department of Justice to do anything about it. So you want to create a remedy for the state to actually do something if it's a smaller, less significant mail fraud, right?
Mr. Chairman, and the substitute just makes it clear on some of the.
Okay, can you, Ms. Fry,
We did, okay.
describe really quickly how the sub is different from the original one?
Yes, Mr. Chair. The substitute is different from the original. Notes.
Or did Sabrina, did you do it?
Sorry. This is me.
I know we clarified the definition of private common mail carrier. We dealt with the whether it's knows or reason we should have known language. Centralized mayor, tear down. We'd made some changes to those definitions, right?
Lines 13 and 14, lines 22, we use delivery service in the definition of postal service, which makes sure to exclude USPS from the definition of delivery service. It's more consistent with other portions in the code. Lines 26 through 29, there were multiple changes. We inserted knows or reasonably should know on line 26 to clarify centralized mail. We amended lines 26 through 29 to read to any mail receptacle located in a cluster mailbox unit or other mailbox panel used for the purpose of centralized mail in any neighborhood, including any condominium or apartment complex. Lines 31, we struck tears down and takes and inserted removes, injures, or vandalizes. And we also changed multiple instances of the postal service to a postal service in conformance with code.
Okay. Mr. Benjamin, did all those fixes take care of the concerns by the work group? Okay, all right. Why don't we take support and opposition? Is there anybody opposed to the bill?
Any attendees online opposed to the bill, please raise your hand and turn your cameras on.
Okay, it doesn't look. That's a good thing. All right, why don't we get supporters to come on up? I know there's a couple supporters, bankers. Is that Vaca? Is it Vaca? Who are you?
Support.
Okay, go ahead.
Members of the committee, Virginia Bankers Association, we appreciate the putting this bill in. We've seen a significant rise in check fraud over the last several years as the criminals went old school and are knocking off postal boxes and postal workers and stealing the keys to those common mailboxes that you referenced in the definition substitute. And a lot of that is through the theft of mail. So we're taking, as the chairman said, some gaps in the prosecution at the federal level where these penalties already exist, and authorizing local law enforcement prosecutors to step in when that occurs. So we encourage you to support the bill.
Next.
Mr. Chair, members of the committee, Corey Conner from Virginia Association of Community Banks, to Senator Deed's question, during a 6-month period in February and August of 2023, the Financial Crimes Enforcement Network received 469 Bank Secrecy Act reports of mail theft-related check fraud in Virginia. That's 11th highest in the U.S. As relationship bankers, community bankers know their customers in real and meaningful ways. Through those relationships, we promote access to services, prevent fraud on the front lines, and give customers a resource when they fall victim to fraud or scams. While community banks are part of the solution, they cannot do it alone. Virginia's law enforcement community must have the tools necessary to effectively deter fraudsters from committing mail theft crimes. We support the legislation.
Other people in support?
Mr. Chairman, members of the committee, my name is C.J. Vatipal, same with the Virginia Credit Union Association. We support this legislation for the reasons already spoken about by the bankers associations as well. We're continuing to see upticks of fraud across the country, particularly here in Virginia, and doubling in size of check fraud over the past 4 years. We ask that you support this legislation.
Okay. Justice Ford, we already called for opposition. Now, you were standing there for opposition? All right, come on up. I didn't see you.
Brad Haywood with Justice Forward. In general, we obviously oppose creation of new crimes and new felonies, but the conduct that's encompassed by the bill language appears to be already punishable as larceny and other crimes. And I'd like to point out another potential problem with this legislation, which is that the people who carry mail are federal employees, and to the extent they would be required for any trials, they're immune from subpoena power in the Commonwealth of Virginia. I don't know if people know that, but state subpoenas do not work on federal employees. So perhaps there are cases where you won't need the mail carrier or any evidence from the U.S. Postal Service, but if the Commonwealth does need them, it's going to be awfully difficult to produce that by the Commonwealth and by the defense if they need that in their own defense. So for those reasons, we oppose the bill.
Okay. Anybody else in opposition? Okay, close that up. Senator, is there any reason why there's a mandatory restitution instead of just leaving it up to the court?
I'm not sure. I can leave it to counsel for.
Huh? It's a policy question. It's not really a legal question. Is there some reason you think they have to have restitution ordered as opposed to just letting the court decide whether to do it or not? Okay, would you'd be opposed to striking that sentence? The mandatory restitution?
I'll be opposed.
Okay, is there a motion to do that?
So moved.
It's been moved and seconded. We strike lines 33 and 34 from the bill. All those in favor say aye. Aye. Anybody opposed?
Move to report as amended.
Okay, it's been moved and seconded that the bill be reported and re-referred to finance. Clerk will open the roll. She's in.
Ayes 13, no 20.
Okay, thanks, Salim. Okay. Carol, if we want to do discovery? Okay, Carol Foy and Srinivasan have agreed that he's going to be rolled. So Deeds moves, Carol Foy seconds, that we roll Senate Bill 1355 into Senate Bill 963. both be listed as chief patrons. All those, or clerk will open the roll. Carol Foy, I think you have a substitute, is that right? Yes. Okay, Carol Foy moves, Deeds seconds the substitute. All those in favor say aye. Aye. Anybody opposed? No. Okay, substitutes before us to Senate Bill 963, having to do with discovery. Where's my version? Where's there? Oh, we have a new one?
No, it's just not in the packet.
Oh, okay. Sorry, we're getting the sub distributed. Go ahead, Senator.
Timely discovery. Prosecutors provide discovery in a variety of forms. Some provide hard copies of discovery materials. Some do discovery in other electronic formats, such as disk, hard drive, email with PDF. But there are some prosecutors who oppose discovery form and ask for defense counsel to use practices that are inefficient and wasteful, such as refusing to allow copying of police reports, requiring lawyers to hand copy or dictate and transcribe those reports and other discovery materials, refuse to provide a copy of the prior criminal record, refusing to utilize the body-worn camera partner share that the state is paying for. In multiple other jurisdictions, some prosecutors have failed to provide discovery, period. So what this bill does is ensure that discovery is provided in the most efficient and timely manner so that due process rights are protected and valuable resources are not wasted. So a number of amendments and changes have been made after consultation with a number of stakeholders. The proposed bill does three things. Requires all attorneys for the Commonwealth to provide discovery materials for all courts to counsel of record for the accused by electronic means unless such material is prohibited from being distributed by law or impossible to provide by electronic means. Oftentimes, some information will be redacted. Requires provision of police reports in district courts within 10 days of trial upon request of counsel, and defines electronic means based on a definition used in the Uniform Computer Information Transactions Act. That is the bill, and I ask for passage.
Thank you, Senator. Does anybody have any questions for this? This is similar to a bill you did last year, right? It was. It got vetoed, right?
It did.
Okay, but it's different this time. Okay. Yeah, Perry. Perry has a question. All that. You ready, Carol Foy? Yeah. Question from Perry.
Senator Carol Foy, I just had a question about the lines 25 and 26 in the case for in subsection B, at least 10 days. Well, first, let me say this. I think that the providing of electronic discovery by electronic means, when I was a prosecutor, that was my favorite way to provide it, because then there's really no question about what was provided, when it was provided, did I turn it over, did I not turn it over. I actually think it provides protections for both sides, a trail, so to speak, of what was provided and when it was provided. So I actually think it's just a generally good practice for everyone in the criminal justice system. My question is I guess more of a technical question on line 26, where it says it has to be provided at least 10 days prior to the date the case is set for trial. And my question about that is, I'm sorry, I hadn't seen the new thing. I guess my question about that is, I'm sort of reading through here, but, okay, I see. It's corrected in here, and it says basically like the rules of discovery as they currently stand, is that right? Basically, like if police go out and interview a witness, right, 5 days before trial and write a report, hey, I talked to this new person, here's some more evidence, then we would just turn it over as we routinely would. Is that right?
Absolutely.
Okay.
Absolutely. There can be supplementary discovery that's provided. And speaking in the same vein to line 26, if we can also add the words behind trial, preliminary hearing, so that's covered as well.
Okay. Any other questions for Senator Carol Foy before we go to support and opposition? Okay. When we sit at 2 and 2, supporters come on up.
Good morning, Mr. Chair and members of the committee. Allison Powers from the Indigent Defense Commission. This is a commission-supported bill. I know you're all very familiar with what this bill does. we just wanted to highlight that this is one of the many reasons the difficulties in obtaining discovery, specifically having to drive and hand copy police reports, watch body cam footage in the Commonwealth's office and not be able to bring it back, is one of the many reasons that we're losing court-appointed attorneys willing to do this type of work, because they're not being adequately compensated for that additional time. And this bill doesn't ask for anything more than we're already entitled to, and also provides that physical copies can be given if electronic is not possible. So we would urge the committee to pass the bill.
Brad Haywood with Justice Forward, Virginia. So I have lots of personal experience with how how discovery and the way that prosecutors provide it can be weaponized actually to gain a strategic advantage in litigation. Because this happened all the time in Arlington, where I was chief public defender and I practiced with Senator Carol Foy. Essentially, they made us hand copy everything. This is when they claimed to have an open file discovery policy. There's other jurisdictions that do exactly that as well. It is incredibly time consuming, and now it becomes even more of a burden because there's also now body cam footage to review. So all of that, if you're wasting your time scribbling things that's already been typed by another government employee, it keeps you from preparing a defense. And that's the nature of the due process violation. Due process does not require discovery to be provided, but if it is provided, it has to be as easy for the defense to access as the Commonwealth to access, or else it really is making it harder for the defense to prepare for trial. So for those reasons, this is a great bill and we support it.
Can't tell you how many hours I spent in that Arlington room dictating everything I read in the police report, because the Commonwealth attorney there used to not give us anything electronically. Come on up. Opposition, we're going to set it again to 2 and 2. Go ahead. Vaca.
Mr. Chairman, Nathan Green, Commonwealth Attorney for the City of Williamsburg and James City County, here speaking on behalf of the Virginia Association of Commonwealth Attorneys. We do not oppose the concept of the bill or what you are talking about. We are not opposed to trying to fix or remedy that issue of having people come to Commonwealth Attorney's offices and sit there and take notes and be able to write down everything that they could get if we were able to, if they were just sent that. However, and again, I'm working at a bit of a disadvantage because I don't have the substitute in front of me.
Can we get him a copy of the sub? Their input on this is pretty important.
I apologize. What we are concerned about is that for district courts, 7C5 doesn't have the same redaction and restricted dissemination material. So if we have a stalking case, from my reading of the language, we would have to provide a copy of the police report. In Williamsburg, we do that. But we also have kind of a gentleman's agreement that this is restricted dissemination materials. So what we won't see is that police report that on the front page has the victim's name, email, phone number, address, where they work, the address of where they work, their cell number.
Okay, hold on a second. Carol Floyd, do you have any concern about the kinds of things he's talking about? Do you think it's something we might be able to tweak if you guys went off in a corner, or do you want to proceed as is?
Open to redaction of sensitive.
Okay, why don't you all go in a corner and try and see if there's some language you can work on with that, because the rules shouldn't be different in general district court than circuit for redaction if that's in fact what it does, although the language might not be a problem there. I don't know. But why don't you guys, instead of,
The opposition get it all done at one time.
Sure. Okay, why don't everybody come up and say your piece, and then you guys can go talk.
So I apologize, Mr. Chairman. The protection of sensitive information is one thing. The other part of my read, again, of this and it says the attorney for the Commonwealth shall provide this information. I do not believe that you have attorney for the Commonwealth involved in all cases in which there is counsel, that is counsel of record. So now, as we discussed with Senator Deed's bill last week, you are now going to have a prosecutor that is responsible for providing discovery in cases that they are not actually prosecuting. That will come at a significant cost. If we are going to be doing all misdemeanors, we are talking about
Okay, but on this bill, your request on this would be that you only have to do discovery in cases for which the Commonwealth is counsel?
That would definitely help. And
Okay.
the last thing is, even if we're doing electronic, not every office has the same means by which to provide email. Not every office has the same.
I got it, but they can figure that out in today's world. Okay, come on up. And time's expired, but I'd burn some of the questions. Be quick.
Harrison, Commonwealth City of Lynchburg, and my issue is with, in addition to what was already said, the mandatory provision of copies. I understand under that code section, it is referencing Rule 3A11, but we have defense attorneys who strategically decide to not participate in rule discovery. And so if we're required to give copies, yet they're not required to participate in rule discovery, then we've kind of worked around the reciprocal discovery provisions of the rule. And I don't know if the patron is willing to perhaps add some language that clarify that this is under Rule 3A11 discovery here. And I just want to point out, we do have these cases where, we give electronic discovery. We put things on hard drives and share it and do all those things. And we have, even with some of the protections of RDM and protective orders, and I'm glad to hear to amend the bill to provide for that, because we have inmates that have victims' medical records in their back pockets and they produce them in court and things of that nature, that we want to protect our victims and witnesses.
Okay, thank you. Anybody in opposition online? No, okay. Carol Floyd, we're gonna go by temporarily while you go off in the corner and do some work. All right. Okay. Yeah, no, I know he's back. We got some other finance bills to knock out still, though. Aird's not here. Oh, she's back. I'm sorry. Didn't see it on there. Yeah, why don't we do your court appearance, first appearance bill, Senate 1227.
Okay, thank you so much, Mr.
You do? Okay, it's been moved and Deeds moves, Aird seconds, a substitute. All those in favor say aye. Aye. Anybody opposed? No. Sub's before us.
Members of the committee, the substitute resolves issues raised from various stakeholders, and we've reached a bit of consensus here to specific before us the Senate Bill 1227.
On the screen. Thanks.
So it streamlines the process and making stakeholders feel more confident about the implementation elements of the bill. The substitute also clarifies the court's role in appointing counsel, refines language around what information needs to be disclosed, and ensures clear guidelines for attorney compensation. These changes provide a lot more structure and reduce ambiguity within the system. But ultimately, Mr. Chair, this legislation ensures that individuals who have been arrested and are determined indigent will appear for the first time in court with counsel, because to date, that is not what's occurring. And not having counsel at this stage often results in people being in jail pre-trial for days or even weeks before they can challenge their detention or be released on bail. So more specifically, this bill requires that there be counsel present during a defendant's first appearance within jurisdictions that have public defender's offices. Many individuals are released on bail, meaning that the court has determined they are not a flight risk or a danger to public safety, but they're being released between 3 to 14 days after their initial arrest. And this caused a number of unnecessary hardship on those individuals, Mr. Chair. We're currently spending, as you know, billions of dollars detaining individuals who've not yet been charged with crimes here in the Commonwealth. Not only is this a significant concern from a justice standpoint, but it's also not sound fiscal policy. This ensures that counsel is present, and we will be getting closer to the constitutional promise of ensuring counsel at critical junctures during individuals' cases. And Mr. Chair, I know that there was some concern about who will receive access to this. The language is permissive, and based on feedback that we received from a number of stakeholders, to include OES, as well as from the JLARC report, currently that Virginia just wouldn't have the requisite number of court-appointed attorneys, especially within our more rural jurisdiction. This ensures that those hearings are all currently counseled.
Where do you say it's permissive?
1 second, Mr. Chair.
That's the beginning. It says it shall, court shall appoint a qualified, a competent attorney at the front end, and then.
Oh, this is the wrong bill I have in my packet. 1 second.
Counsel, you guys know where? And by the way, just so that people, the public are aware, we're aware the microphones are hopping in and out, not kicking in until we talk for a split second, and we're trying to fix it. I'm not sure we're gonna be able to fix it this meeting though, but we're aware of it. I mean, I see lots of shalls in here, Senator. That's why I'm trying to understand what's permissive, because it looks very mandatory to me.
If it's helpful, I can find 79. I'm not sure if that is the line number for the substitute.
No, it's not in the sub. It's not. 72, 73. Okay.
Where it says, Mr. Chair.
Where there's no PD's office.
jurisdictions having a public defender office established pursuant to 19.2-163.4, the provisions of subsections, so on.
Mandatory if there's a PD, and if there's no PD, it's if you want. Okay. Anything else? Senator Deeds has a question.
Mr. Chair, that makes the bill make sense to me, but do you create equal protection problems with that?
Conflict of interest issue.
Not that I'm aware of.
Is it somebody with the IDC or somebody, IDC, get up here, please. I have a question for you that I'm not sure. It's a lawyer question, I can ask her. I don't know how to properly do a bond motion where I can't say to somebody what happened. Tell me what happened, because the nature of the offense comes up, and you got to be able to have some kind of an explanation. And the reason the PD's office often has a conflict is because you get cases where there's multiple defendants and you're not allowed to know. And as soon as you know what happened from one defendant, you can't represent anybody. So, I mean, doesn't this create a situation where you're going to create all kinds of conflicts of interest? I mean, why not? I don't understand.
May? Briefly? Okay. So I actually practice as a public defender in a jurisdiction that has counsel at first appearance. And I can tell you that what happens is that the accused comes in, I get a copy of the criminal complaint. They oftentimes have a wealth of information, but then also the Commonwealth shares with me any additional information they have, such as the criminal history, any other witness statements, anything that they're going to represent to the judge. I also get to have access to that and see that. And it doesn't delay the bail hearing at all whatsoever. What it does is provide substantive argument for someone's release, or if the Commonwealth meets their burden, their detention. But it is really effective. And so there is no, I understand, I'm about to get to that. So there was an ethics, I believe, opinion back in 2020, which said that making a freedom argument at arraignment was a quote unquote limited appearance and does not present a conflict for counsel making the argument unless you have actual knowledge of a conflict at the time you are making the argument. So I think that addressed your question.
Not exactly. I mean, I understand it's not a conflict at the time, but the problem is as soon as you're in possession of an information that's prejudicial, potentially prejudicial against another client, everybody in the case has to withdraw in the entire law firm. I assume the same rule applies to the public defender's office. And so I don't understand if the person says, yeah, I was the trigger man, I shot the person, and the PD's office has been appointed to represent a different person who doesn't agree with that or prejudice that defense. It seems to me the entire PD's office gets disqualified because we have them hearing first appearance on every single case. And so, that
is exactly what happens. If there's an actual conflict, well, let me back up. We actually do a conflicts check. And so once I get the criminal complaint and I'm able to see who the alleged victim is or the complaining witness, I can do a conflicts check to see if we represent anyone else who's a co-defendant or a complaining witness or alleged victim in that case. And if it is, then I don't do the bail hearing. However, if it's
sometimes all on the exact same docket that morning, don't they sometimes all get picked up at the same time? And
yes, that has happened. So if we're appointed to someone, I make a bail hearing and we are assigned to represent that person, then the next person who comes through, if I see that there is a conflict, then the judge will oftentimes ask or call for a different court-appointed attorney to come into the courtroom to make that bail hearing at that time.
all right. Aaron, we cut you off in the middle of your explanation. You have anything else you want to say?
My explanation.
Okay. God, this audio system's driving me crazy. Okay, why don't we take, is there anybody that's opposed to the bill? Doesn't look like it. Okay.
Yes.
Sorry, is somebody online opposed?
Yes.
Okay, go ahead. Turn your camera on.
On your camera.
1 second.
Set the timer to 2 and 2.
Okay.
My name is Kate. Hello, my name is Kate, and I'm 9 years old. My mom had to stay in jail for a long time before I saw her again. This made me very sad and worried that I wouldn't see her again. If she had an attorney, this would not have happened. Thank you, Senator.
He's in, that's a,
Thank you.
in
I think that was in
support.
support.
Yeah.
And we needed a camera on. God, this audio system is driving me crazy. Anybody else opposed online?
Online.
In favor or opposed?
Valerie Slater, are you opposed or in favor?
That's in favor.
Favor. Favor.
Okay, we'll switch to supporters. It doesn't sound like there's anybody else who's opposed. Reset the timer. Everybody else who's in support, go ahead.
Valerie Slater with Rise for Youth and the Virginia State Conference in AACP. We strongly support this bill.
My name is Jessica Cipollio. I'm with the Williamsburg James City County Coalition for Community Justice. We strongly support this bill. In James City County, we effectively have a system of court-appointed counsel at first appearance. So we've seen this can work in a court-appointed jurisdiction. And believe that this is an important step to reduce our pretrial populations throughout the state and ensure constitutionally provided for counsel. I ask you to support this legislation. Thank you.
Kevin Beckford, you can go ahead.
Kevin Beckford with the Pretrial Justice Institute. I urge you to support counsel at first appearance, CAFA ensuring legal representation at the most vulnerable stage of the judicial process. Not only has the Supreme Court affirmed that legal counsel is essential at all critical stages of the legal process, pretrial proceedings are undoubtedly qualifying. Research shows that CAFA reduces pretrial detention, bail amounts, and jail time, while increasing fairness and compliance. Even brief pretrial detention can cause devastating consequences like job loss, housing instability, and family disruption. Early access to legal counsel makes a measurable difference, and by implementing CAFA, Virginia has the opportunity to strengthen its justice system and protect its communities from the harmful ripple effects of unnecessary pretrial detention. Thank you for your time.
Thank you for your testimony.
Brad Haywood with Justice Forward Virginia. My career as a public defender for 8 years. They've been doing counsel at first appearance for over 21 years. And in response to the concerns about conflicts of interest, you don't really have that. One, if it's a co-defendant case, they're almost certainly there together, so you know you're going to have conflicts. You can only argue and in addition, because of the nature of those hearings, you're really only collecting. You're not going to be talking about confidential details, privileged details. You're going to be talking about biographical information, demographic information, address, job, things like that. That doesn't create conflict. So
Okay. All right, time's expired, so just come on up and say who you're with and that you support the bill.
We strongly
lean into that mic.
It's not working.
with the Virginia Interfaith Center for Public Policy. We strongly support the bill. Thank you.
Oh, my name's Alan Brothers. I'm with the Pretrial Justice Coalition. Strongly support this bill.
Maisie Osteen, I'm with the Legal Aid Justice Center, and we also strongly support this bill. And also just to say that there's a rational basis for the decision, and that's why it's applying to public defenders' offices. Thank you.
My name is Mike Berryman. I'm with the Humanization Project, and we enthusiastically support this bill. Thank you.
Chris Kaiser, ACLU of Virginia, here in support of the bill. Thank you.
Cami Blatt, policy analyst at the Commonwealth Institute, and we strongly support this bill.
Virginia Majority, and I support the bill.
Mr. Chair, again, I would just close by saying that I want to thank all the partners and stakeholders for all of the input into this bill. Again, I do think that this will be a significant step forward in making sure that all individuals get the necessary representation they deserve. I hope we can move the bill forward.
Okay. That closes testimony. Is there a motion?
Report and refer to finance.
Second, the bill be reported and referred to finance. Clerk will open the roll.
Thank you, sir. Thank you.
Okay. Okay. Bill goes to finance 10-2. For those of you who just showed up, Locke and Diggs, we have 2 finance bills left to do. We didn't have people in the room, and so I thought we ought to start getting the non-finance patrons in here. That's why I suggest you come down. These next 2 bills will probably take 30 minutes. 30 total.
We have the felony homicide bill. What about,
Okay.
did we already do the Adams bill?
We gotta get
No,
the finance
I
bills
don't
out
think
of
we
here.
did Adams bill.
We still have Scott's.
So why don't we take my bill next? Senate Bill 1012.
Bill is before us.
1012.
You can proceed with your testimony. Mics are not working.
And Eric, you're sharing again.
Substitute, Mr. Chair.
I think I do.
Can we get the substitute before us?
I moved myself.
Seconded. All those in favor of the substitute, please state aye. Any opposed? The substitute is before us.
I think we have 4 bills left that are finance.
Thank you, Madam Chair. I need to stand up a little bit. Been sitting down for the last 3 hours. So,
Well, Mr. Chair, go ahead.
so basically, what this bill seeks to do is to create the ability for civil accident or collision victims to be able to hold people accountable for using their phones in car accidents. Right now, the problem that exists is whenever there's a collision, if anybody's on their phone, most of the evidence is destroyed by the time any kind of litigation is commenced. So, also, given the lack of information collected by law enforcement, it's often impossible to even try to attempt to preserve a lot of this evidence. So, basically, what the bill does is, I'm going to start at the end. But if you look at the collision report piece, first of all, under 462373, it says anytime there's a collision, it requires law enforcement to ask whether or not the person was using the phone at the time or not. And it requires the law enforcement to also collect the person's mobile phone number and their mobile phone carrier. The reason that's important is because you can't contact the carrier to come preserve anything if you don't know who the carrier is. So it's important to know that. And then secondly, requires the law enforcement to collect the person's IMEI number, which is also necessary in order for the cell phone company to be able to preserve it. It requires the information provided in the accident exchange form that the 2 people subject to the collision have given. I just want to note that I attended a safety conference at the NCSL this year before the main event in Louisville. And we heard a presentation from a company that analyzes data that's provided by insurance telemetrics software. As many of you all know, insurance companies are now giving people insurance discounts if they install apps on their phones. So when they're carrying their phone in their car, it collects information on the driving behavior. And so these companies are able to analyze this telematics data. And according to official reports, cell phones are reported as the cause of a collision in 2% of cases. However, when this company analyzes telematics data from the insurance companies, they find that cell phones are involved in 30% of accidents. So in other words, everybody's lying to the cops about whether they're using their phone when they're in a collision. Which is the exact point of being able to capture this information so we can help accountable for it and start to pay less money on our insurance. So, first of all, it requires law enforcement to do that. The second thing the bill does is it says that an injured person can send a letter to the carrier of an official form created by the Supreme Court of Virginia that basically requires the cell phone carrier to preserve information around the time of the collision. The reason it's important is because if the carrier, Verizon, T-Mobile, Sprint, whoever, Mint Mobile, whatever, if they don't preserve that information, by the time litigation's filed in a year or 2 or 3, it's all been destroyed because of document retention policies. They don't save things that you need in order to be able to show us whether somebody's using their phone or on their phone at the time of the collision or not. So all this does is puts the phone company on notice that they need to preserve certain stuff so it can be safe. In my experience, other types of entities will do it. So, for example, I'll often send a letter to the dispatcher and say, can you please save the 911 tape? They're often happy to save it for me pending the receipt of a subpoena when litigation commences. But mobile phone carriers don't have to do that. There's no need for them to do it. This requires them to do it. And the last thing it does is it makes clear that if an attorney representing a person who's a victim who's been injured sends a letter to the putative defendant, the person that caused the collision, and tells them to preserve certain information on their phone so they don't destroy it, that there's a consequence to the person if they don't destroy the information. It creates a clear structure for that, and that's what the first part of the bill does. So basically, the bill does 3 or 4 things, all of it designed to hold people accountable, make it easier to hold people accountable for using their phone when they're in a collision, which, as I've said, has been found to be responsible for 30% of collisions, even though we can only prove it happened in 2%. And so, at the end of the day, what this will hopefully do is get people to stop using their phones while they're driving, enable better accountability, and will also save everybody a lot more money in their insurance, because we are all paying for this in our own insurance bills every day, and also people's lives and injuries and our medical bills, everything. That's what it does.
Mr. Chair, question for you. Can you clarify exactly what data the telephone provider would be asked to turn over to you in the event they receive, this moves forward and they receive sort of a notification asking them to retain the data on this individual?
Well, first of all, you would get whatever you would get in response to a subpoena, whatever you can subpoena, all kinds of different things. But what the bill basically requires the mobile phone carrier to preserve is set forth in this new section 8.01417.02, which is subscriber information, incoming and outgoing call logs, text message logs, IP addresses, MAC addresses, unique identifiers, history of websites or servers accessed by the phone, including date, time access, real-time location data, real-time communications, surrounding the time of the collision, 2 hours before and 2 hours after, 2 hours before the collision. So it's only information that happens right before the collision happens, so you can see what they're doing right up until the point they were driving. I'll tell you, I mean, part of the reason it's important is that law enforcement, this is the kind of stuff law enforcement will get if there's a death, but it's not stuff that law enforcement really gathers if somebody's not killed. I mean, I learned about a lot of this stuff. I once had a case where the guy was killed by, his car broke down, his blinkers were on, he got out to push his car off the road. Some guy plowed into him at 60 miles an hour because he was texting with his girlfriend about the sex they just had for the 30 minutes leading up to the collision. The cops were able to prove that because they grabbed the phone and they saw it because they knew there was a death. Most other cases, they don't do that.
Just one additional question, Mr. Chair, and then I'll ask the committee if they have questions. The individual who might be on the other end of that call or that message, there is no expectation of privacy on their end. Is that correct?
Well, the only thing the record, that's correct. Well, once somebody's been in a collision and you've injured somebody, you kind of lose your expectation of privacy once the litigation commences. And by the way, you got to remember that this information that's saved, the only way you would get it is by issuing a subpoena. At that point, the party, the defendant, would have the opportunity to move to quash the subpoena, say it's overbroad, we don't want you to give that, or they can fight about that in court. So you only get what the judge would allow you on the subpoena. This just ensures information is preserved. So, the only thing it would show, the only thing that, in theory, this would show is what was sent from that phone or who was called. What was said in the call would be captured, and the text messages, substance of those would only be captured if the phone company kept them and they were provided by subpoena.
Is there anyone on the committee with questions for the chair? Do you have anyone here in support of the legislation?
Any attendees online in support, please raise your hands and turn your cameras on.
Madam Chair, members of the committee, Elliot Bucker on behalf of Virginia Trial Lawyers Association, in support of the bill.
Thank you so much. Do we have anyone online in support of the bill? Do we have anyone here in opposition to the bill? Come forward, please.
Any attendees in opposition online, please raise your hand and put your cameras on. Madam Chair.
Yes. Yes, let's set the timer, please, for 5 minutes. Yes, please.
Members of the committee, according to VDOT, there were about 122,000 crashes in Virginia in 2022. Of those, about 1 in 6 may have involved distracted driving, according to VDOT. Of all the cases that have resulted from car accidents, maybe about 5,000 actually lead to a lawsuit being filed.
I can't hear it.
But under the terms of Senator Sorgel's bill, every one of those 120,000 accidents potentially could lead to one of the requests for which he creates the authority here. This is the lawyer can do that before even alleging a particular cause of action relating to distracted driving. Cases of this kind, this data is produced. We preserve it. In our industry, it varies, but from a year to 18 months, and maybe in some cases longer. The many categories of data that are required to be preserved under this are, it's onerous. It's a lot, and it's an individual manual process for each one. I'm pretty sure if we were to comply with this, we'd be at odds with a couple of federal privacy statutes. And this is just unnecessary. This kind of discovery gets made successfully all the time, and it is a big old can of worms, and I think we need to go back to the drawing board on this one respectfully.
Madam Chair.
One moment. We have a question for you, sir. Senator Obashane.
Just ask, who are you and who do you represent?
President.
Okay, thank you.
Please remember to state your name, who you represent, and just be mindful, the time remaining is for everyone.
So, representing U.S. Cellular, for the reasons previously stated, we oppose the bill.
Thank you.
Troutman Pepper, representing the American Property Casualty Insurance Association. We're concerned with all the reasons previously stated regarding privacy. I would ask everybody to think about how much they get on doing their cell phone and other thing for 2 hours before, 2 hours after. That's 4 hours that one letter makes you keep for 3 years. No matter if the phone is belonging to you, your employer, the state, the federal government, you want to switch plans, you're responsible for that. We get a charge of spoliation against you at a court of law. Secondly, your 22-year-old gets in an accident when ICE is the problem. They get a letter from a lawyer, they throw it away, there'll be a charge of spoliation. Distracted, no matter what the facts, the circumstances of the case are. It's a bad bill. We oppose. Thank you.
Thank you.
Kevin Logan, I represent Virginia Farm Bureau Mutual Insurance Company, and for all the reasons stated, Farm Bureau opposes the bill as well.
On behalf of T-Mobile, for all the reasons previously stated, we oppose this bill. Thank you.
Thank you.
Good morning. Joe Huckins with the Insurance Agents of Virginia. We oppose the bill for all the reasons that you've heard. Thank you.
Thank you.
Good morning, Madam Chair, members of the committee. Garrett McGuire with AT&T, and as everyone has already stated, we oppose the bill for many of the same reasons. Appreciate it.
Thank you.
Elizabeth Holmes with the Virginia Sheriff's Association. We oppose the bill as well.
Thank you. Senator Obenshain.
All of the others, none of the other people who testified surprised me at all, but why on earth does the Sheriff's Association have an interest or care about this bill?
The second half of the bill is the obligation of the law enforcement officer who's writing an accident report to extend their investigation beyond what would be required under their authority as investigating crime or a traffic violation, and extends an obligation to essentially collect and provide information used for civil litigation only, which is beyond their statutory authority to investigate crime and traffic violations. And it's asking for information that is often not in the possession of the driver, certainly at the time of the accident. IMEI number is not something we have readily available.
Senator Obenshain.
Police accident reports already require you to collect the name of the insurance company. I mean, isn't that the same thing?
Well, I think it's significantly less onerous than collecting technologically obscure, if you will, information such as the IMEI.
Senator Obenshain.
As closely, I think, as she can. Thank you.
Members of the committee, Trucking Association. Our concern of the bill is oftentimes people that own trucks and work vehicles don't own the phone of the driver. And we're concerned about the impact that the presumption of spoliation will have on the company when a driver refuses to turn over the information or cooperate with a law enforcement officer. Thank you.
Do we have anyone online in opposition? Senator Servo, you want to provide your closing comments?
Sure.
Madam Chair.
Senator, yes, go ahead. Ferry.
Senator Zerval, I just have a question about, I had I used to sit on our crash fatality team, and I would go out to these fatal incidents in the middle of the night. And I had a case where a guy was on his cell phone using Twitch, which I guess is like a little gaming, whatever, younger people than me know what it is. And he's looking down in his lap and runs over a guy who's riding home on his bicycle at night. From everything we could determine with lights, and had his little grocery bag that he was taking home, and he just runs right over him. But the way that I read your language, do you think that would you be able to get that? It doesn't seem. I'm asking if you think in lines 32, 33 through whatever 30, wherever that ends, if you would think that kind of like I'm on my phone surfing the internet, if you think that would be covered as well or not.
It's probably not covered by that section. I think you probably would be able to determine that from the information that the phone companies would hopefully keep. If you look under subsection, lines 50 through 51, they have to preserve the history of the websites or servers access, including date and time access. Presumably the Twitch app would be accessing certain IP addresses, so you'd be able to go back and see that that app was active and being used and accessing information at the time, to which you can potentially draw conclusions.
Thank you.
Madam Chair.
Senator Deeds first, and then Senator Carol Foy.
I wondered also about the language on lines 74 and 75, when you're just asking about, there's an obligation to ask about the driver's mobile phone usage, and does the word phone there imply talking on the phone and not necessarily usage of any apps or maybe a mobile device?
I'm fine with device if you want to change it to that.
I'd make that motion.
It's been moved and properly seconded to add in device. All those in favor? Aye. Any opposed? That change is made. Senator Carol Foy.
Thank you, Madam Chairwoman. Quick question for the patron. I see that. Thank you. I see that I believe, and I apologize if this has already been addressed. I was in the corner working on another bill, but I think it was 3 years preservation under D, subsection D. However, the statute of limitations for personal injury is 2 years. Is there a reason why you're asking for 3?
Yeah, because sometimes when there's a collision, or a personal injury case, you'll file a complaint. If your client is not done healing yet while you're trying to settle it, you might not serve it for another year. And the only way you get the information, this bill's only a preservation bill. It's not a disclosure bill, it's a preservation bill. And so you might not be in a position to issue a subpoena until you serve the lawsuit. You have another year to serve it after the statute runs. You file it right up at the 2-year deadline. So that's where I got the 3 years from, was for that. Because otherwise it might force you to serve the lawsuit before you're really ready to or want to, so you can get that information, so you don't, in case you're ready to destroy it. That was what the 3 years came from.
Closing comments, Senator.
Yeah, thank you,
Madam Chair.
Senator Obenshain.
Couple of questions. I'm going to vote for this. I do wonder about whether there's some violation of federal law with respect to the time period that the carriers are required to retain that information. I'm sure that as this perks along forward, you'll look into that. I would also point out that I had no idea actually what an IMEI was, but I looked to see how much of a burden it was going to be, and what you do is you dial *#06# on your phone, and your IMEI pops up. It will take exactly 15 seconds for somebody to do that.
5 seconds by going to my settings.
Exactly, or through your settings. So, I find that unpersuasive. So, I run into this. I do wonder whether a shorter period than 3 years might be something the patron might consider. But by and large, this is something that is important. I think anybody who's represented someone where they've had a concern about distracted driving has had difficulty trying to get this information. Spoliation letters to drivers, are seldom very effective. I think the only way to do this is in a way like this bill requires.
Senator O'Mashane, does that complete your questions?
Right, isn't that true? Yes.
All right, I believe this would have to be reported and referred, is that correct? Okay, Senator Servell.
I'm really kind of mystified by law enforcement's response to this. There's all kinds of information law enforcement gathers in a collision case that some of it relates to the prosecution, some doesn't, but whether somebody's on the phone or not, it directly relates to why a collision happened. And I don't know why you would never ask somebody that as part of an accident investigation. I mean, it's standard. And if you're really serious about proving it in court, and you'd really want to get to the bottom of your law enforcement, these are things you would ask for. So that part mystified me. With regard to the rest of it, I understand that the insurance companies don't want to do something. It requires a little bit of effort on their behalf. It might require an extra person hired. But taking this information whenever they get this letter, putting it in a PDF, and parking it on a server somewhere for 2 or 3 years until a subpoena is received, not a big deal. This bill is not a bill that requires disclosure of anything. The person in the collision could say, I'm not answering any of your questions. There's nothing in here that requires them to answer a question. The bill doesn't require any of this information to be produced. That only happens when a subpoena is filed in the civil case and the defendant has an opportunity to come and say, I think two hours is too much. I think texting is inappropriate. Whatever. They can argue that to a judge. And if a judge wants to, and the judge can look at it in camera. If there's stuff that it's in the text messages, the calls, judge can look at it in camera, say you're only getting this, you're only getting that. All this bill does is requires records to be preserved so that the truth can be discovered when and if a lawsuit's filed. And the last thing I'll just say, I just want to reiterate, the federal stuff, news to me. I've gotten many calls from the carriers over the last 2 years. I've given this bill to them and asked them for feedback. Nobody's given me citations. Nobody's given me an amendment. Nobody's given me language to fix. Nobody's given me anything that I've been able to look at to confirm whether it's true or not. The reality is that distracted driving is causing 30% of the collisions in our state, and we're only able to prove it 2% of the time because of the problems presented by this bill. And this would help solve that problem. I'd hope we could pass it.
Thank you so much, Senator Servell. We again have Senate Bill 1012 before us. What's the committee's pleasure?
Move to report, referred finance.
Is that a second? It's been moved and properly seconded. Open the vote, please. That bill does not proceed. I return it back over to you. Destroy the roll. Let's recast that vote, please. That bill dies on a time vote. Mr. Chair, I turn it back over to you.
Thank you, Senator. Now we're going to McDougal, you ready? Or? Yeah. Can I? You have another one? It's finance? Oh, okay. Let's go back to Carol Foy's bill.
Thank you, Mr. Chair. For Senate Bill 963, I believe we have a few line amendments. If council would proceed.
On line 24, after "in any district court," insert "in any case prosecuted by the attorney for the Commonwealth, comma." And then on line 26, Mr. Chairman, the senator has already asked that the words "or preliminary hearing" be added at the end of line 26. Following those words, we would add this language: provided that counsel of record agrees to such reasonable redaction or restricted dissemination as may be requested by the attorney for the Commonwealth.
Any questions about the amendments? Okay, Deeds moves, Aaron seconds the amendments. All those in favor say aye. Aye. Anybody opposed? No. Okay. Okay, the bill's now before us. We've heard testimony on this. I think we've done support and opposition.
So moved.
Right. Any other questions? McDougal, you weren't here for a lot of this.
I was stuck upstairs.
But basically, Vaca said they didn't oppose the sort of concept of the bill, but they wanted some edits. Carol Foy went off in the corner and worked on them for it. You guys are better or okay? Better. Not okay?
Can't say support, but better.
Okay. Okay. Any other questions?
So moved to report.
It's been moved and seconded. The bill be reported and referred to finance. Clerk will open the roll.
Ayes 9, noes 3, abstentions 2.
Okay, bill reports refers to finance. Now, that leaves us with two finance bills. One's getting rolled. Before we do that, we got a little cleanup to do. McDougal didn't want to be rolled into my ceiling bill. So Deeds moves, having voted on the prevailing side, to report and re-refer ceiling bill to finance, that be reconsidered. Aird seconds it. Clerk will open the roll.
Bill was 1412.
I think it was 46, I think. So what was it? Ceiling?
Yours was 1466.
Yeah, 1466. We got to reconsider it first. Okay.
Ayes 14, no 0.
Okay, bill's now before us. Having voted on the prevailing side by which McDougal was incorporated into Surville, Deeds moves that it be reconsidered. Aired seconds. Clerk will open the roll on that.
Ayes 13, no 0.
Okay, McDougal's bill will now go by for the day. Deeds moves and Aired seconds that 1466 be reported and referred to finance. Clerk will open the roll. As amended and subbed. 1466.
All right, can we have, I need to redo.
Just verbalize it to him. Stewart was an abstain, yeah.
Stanley, abstain, Jordan, no, Keith is a yes, Odin changes no.
You got it right.
Yeah, you got it.
Ayes 9, noes 3, abstentions 2.
Okay, so we have two, hold on, why don't we knock out these, why don't we knock these quickly?
Yeah, that's fine.
So we still got maybe about,
I'm just trying to accommodate you.
we got about 45 minutes, and Locke and Diggs have been down here twice now. So why don't we do Senator Locke, Rules Chairman, Caucus Chairman, why don't you come up here and do yours, and then we will do Diggs, then we'll go do the felony fentanyl murder bills. So Locke, you've got 1460, writ of vacatur. We saw this a couple years ago I think it was a Delaney bill or maybe Herring bill we did on this. 1460.
I still feel that's good finance. Senate Bill 1460 addresses the issue of human trafficking. Traffickers have absolute power over their victims, subjecting them to severe trauma, manipulation, coercion, and force. Push victims into illegal activities they would never have chosen for themselves. These crimes frequently lead to arrests and convictions, which traffickers use to control and trap victims in a cycle of abuse and exploitation. Unfortunately, too many survivors are not recognized as victims while navigating the criminal justice system. Because of this, the victim, rather than the real perpetrator of harm, is convicted. As a result, criminal records are a lifelong burden for survivors, blocking them from accessing essential resources like counseling, housing, education, and employment, keys to rebuilding their lives. Under current Virginia law, only convictions related to prostitution or keeping and/or residing in a bawdy house can be vacated. But the reality is that many survivors have criminal records tied to offenses like felony drug possession, theft, or fraud, crimes they were coerced, deceived, or forced into committing by their traffickers. In order to fix this, we must expand Virginia's law to allow survivors of human trafficking to petition for the removal of these additional criminal convictions. By doing so, we can give survivors the opportunity to rebuild their lives, regain their independence, and break free from the lasting effects of past abuse. So Senate Bill 1460 seeks to expand the list of offenses eligible for vacatur and expungement, including a number of misdemeanor offenses and felony drug possession based on statistics and trafficker exploitation. This legislation will offer survivors a fresh start by clearing their criminal records, which will help them access the support services they need to heal and move forward. This bill is an essential step in breaking the cycle of victimization and criminalization. It will allow survivors to rebuild their lives without the weight of past offenses holding them back. And that's the bill.
Okay, thank you, Senator. Our work group had a couple questions about these new definitions. Mr. Benjamin, what was the concern with the new definitions of labor trafficking and sex trafficking and victim of human trafficking?
Concern, Mr. Chairman, was only that these concepts.
Make sure your mic's on. Oh, yeah, I'm not hearing it. Okay.
The concern, Mr. Chairman, was only that these concepts and these terms are used throughout the code, and you were recommending that at some point the committee to examine the definitions of codifying language that could conflict with other code sections. I mean, no harm to the bill. It's just a technical concern that we had.
Got it. Okay. 1092. Have we dealt with Jordan's 1092 yet? No, not in this. Not today. But Sabrina or council. No. Is that for Wednesday? Okay. We're gonna have to compare those two. There's another bill, Senator, that has human trafficking in it, and having two different definitions in the same title could be a headache. So, okay, any other questions for Senator Locke?
Mr. Chairman, I'm having a hard time getting the system to pull up today. I think it must be too much traffic on it. But when individuals came to me in the fall, I had a couple meetings. One of the questions I asked them, and I just want to make sure the version is still as it is there any requirement that the victim not be engaging in human trafficking at the time they're asking for this relief? Is there any requirement that the person asking for the relief not be currently involved in the same human trafficking? So, Mr. Chairman, I'm trying to make sure that this is somebody's not still engaging in the activity, and the prior version I saw did not. I can't pull it up right now to look at it, so that's why I'm asking the question.
I have a lifeline.
I think she's the one that spent a couple hours with me in the fall.
Good morning, committee chairman. My name is Meg Kelsey. I'm with the Center for Global Justice at Regent Law School. About a year and a half ago, we launched a clinic representing survivors in these petitions. And while, to answer Senator's question, there's no explicit requirement similar to the petitions for expungement, the Commonwealth is a party. The judge gets to review as well to look at the dates of these offenses and review the affidavit and review the evidence. And so in reviewing other states who have this relief, even much more expansive relief, there's no evidence of essentially gaming the system of people who are still being trafficked, also petitioning and coming back and forth. So there's no evidence, even in New York, where their relief, vacatur relief, is for any offense caused by trafficking, not just the enumerated offenses we have here. There's no evidence of that. And we believe that's because of the barriers inherent within the petition process. The petitioner is exposed to the justice system and showing their record, giving their story. And so we believe that with the discretion of the Commonwealth's attorneys and the judges, that's not a concern.
Okay. McDougal, any other questions? Okay, any other questions? No, well, no. We haven't even taken opposition yet. Okay, Senator Locke, I assume that's your statement in support, yeah? Okay, is anybody else in support?
Any attendees online in support, please raise your hand and turn your camera on.
Mr. Chairman, members, Tom Torch with the Virginia Catholic Conference, we support the bill for the reasons stated. Thank you.
Thank you. Okay, next. Anybody else? Come on up. Come, let's go. Talk.
Good morning, Senators. My name is Desiree Trail, and I'm a survivor leader of human trafficking here in Virginia, and I represent Virginia Coalition Against Human Trafficking, the PD-16 Human Trafficking Task Force, as well as Global Centurion. My charges, which include drug possession and prostitution, were accrued while I was being trafficked. I did not recognize myself as a victim at that time, over 20-some years ago. I have sought vacatur for 20-year-old nonviolent felony since 2016. I represent thousands who have endured similar traumas, such as being beaten, being raped, being stabbed, being held hostage, being drugged, and yet I still have not been able to find relief. My good friend Barbara Amaya helped draft the first set of vacatur legislation in 2014. She died last year on January 20th without relief after all her hard work in this movement. I ask you to please pass this bill today after all of these years. And in closing, I urge you to consider this. If our highest offices allow our national leaders to be able to pardon family members that have been convicted of criminal records, or if our highest office in the land can be occupied by someone who's been convicted of felonies, would you please find it in your hearts and have mercy on us today to grant vacatur to those that have greatly suffered, such as myself and those that are standing behind me. Thank you. Have a blessed day.
Thank you. I got 2 seconds left, so if you could just come up and say who you're with and we support the bill.
Olivia Raposa. I am a survivor leader and advocate. I am a local nonprofit director at Survivor Ventures as well, and I'm in support.
Thank you.
Sanu Jan Cooper with the Virginia Sexual Domestic Violence Action Alliance, and we're in support of this bill.
Okay. Attorney General supports.
Pleasure to work with these stakeholders during the work process, especially the Attorney General supports the bill.
Okay. Remember, I'm not a judge yet. Okay, come on up.
I'm a survivor leader, and I am in support of this.
Thank you. Okay, switch over. Is anybody opposed to the bill? Reset the timer. Nobody opposed? Anybody opposed online? Okay, bill's before us. Any other questions?
No, you've got it. Moved and seconded.
Re-referred to, doesn't need to go to finance, right? This is a non-finance bill. Yeah, so it was moved and seconded, the bill be reported. Clerk will open the roll.
What are you doing? I don't know. What are you gonna do?
I'll vote no if you vote no. Although Pete's got my vote.
I know.
I didn't vote.
Abstain.
Go ahead. And
Yeah.
what do you want to do?
Abstain.
No.
Okay, thank you. And sorry for all the waiting, Senator. Okay, Diggs has one. He's promised me he's going to be quick because we still have 3 finance bills left. I forgot about another one. So, Diggs, you've got 750. The big question, I think, on 750 is, isn't this already a crime?
No, sir. This is to clarify that it's not already a crime. So this would expand current state traffic law to prevent unlicensed minors from driving. What this does is it creates a class 1 misdemeanor for a parent to knowingly allow a child that is not licensed to drive a car. And this comes about as an offense in York County where 3 young people were killed as a result of a parent that was allowing a child to drive for at least 30 days. And so we've got some people here who are were victims of that and are experts in youth trafficking.
I think Senator Perry has a question for you.
And Senator Diggs, I'll be honest, I have a question for you. Occasionally this happens whenever I get bills or things come in, and it's confusing to me because I think I prosecuted this crime. I know I prosecuted this crime, and this is one of those. And so I started scouring the code for it, And we would get them in juvenile traffic court, which in Loudoun happens Wednesday, 10 a.m. And my recollection is that it was a class 2 misdemeanor. And so I scoured the code for it, and I pulled up 462349. And what that code section says is, no person shall authorize or knowingly permit a motor vehicle owned by him or under his control to be driven by any person who has no legal right to do so, or in violation of any of the other provisions of this chapter. And then 462350, the next one says it's a class 2 misdemeanor. And so I guess my question is, it sounds like what you're trying to prohibit is, hey, I'm a parent, my unlicensed juvenile, or quite frankly, under this statute, anyone who owns a motor vehicle or has the control over it to allow any person who's not licensed to drive, and it sounds like that's exactly what your bill is aimed at.
Explain why those statutes don't apply, Senator? Do you?
No, sir, I cannot. Maybe Ms. Guido might have some additional knowledge of this, as she's an expert.
Okay. She the victim's. Hi, welcome to the committee.
Good morning, Mr. Chair and committee members.
You have an answer to the legal question, or you want to tell us your story, I guess?
I'm going to do a little both, if you'll allow me.
Okay. I'm going to set it to 2 and 2 then. Go ahead.
He was killed by an unlicensed reckless driver whose parents allowed him to drive each and every day for over a month to and from school. Although parents knew it, students knew it, teachers knew it, bus drivers knew it, no one spoke up. What we're asking for you to do here today is to make it crystal clear in the law that you may not allow anyone you know to operate a motor vehicle outside of the rules in the state of Virginia. It is no different than guns and alcohol, code 18.2.56.2 and 4.1-306. Those make it explicitly clear in the state of Virginia that you are not allowed to do that and hold those people accountable. Minors need protection. We need parents to be parents, and we need this committee to say no more lives lost. The state police estimate 1,634 people have been issued citations in the last 3 years for driving without a license. This is an epidemic, and this is something that needs to be clarified crystal clear in the law, that we are not going to allow this to happen any further on our Virginia roadways. So I ask you, take a look at my son. Look at your families, look at the people on our roadways, and ask yourself, do they deserve to be protected from underage, unlicensed drivers? We're not talking about a teenager who steals the keys. We are talking about parents, guardians, adults who knowingly allow this to happen. I please ask you to consider this, and thank you for your time.
Okay, madam, thank you for your testimony. Sorry for your loss. I'm sure it was hard. I'm sorry you didn't get the justice you felt like you deserved on that. So I'm going to hit pause for a second. So, counsel, if we looked at 46.2349, is this not covered already?
Yes, it's covered by 349.
Okay. Do you have any understanding as to why this person wasn't charged under 46.2349? Probably a traffic infraction, maybe? I don't know. Huh?
I think the question from Senator McDougall was, what's the penalty? And I think the difference is that, between the senator's bill and this penalty is that 350 says, hey, if it doesn't specify, it's a class 2 misdemeanor. So the next code section over says. So I think the technical difference from what Senator Diggs is proposing is whether or not it's a class 1 misdemeanor or a class 2 misdemeanor. So you're looking at 12 months versus 6 months and a differentiation in fines.
Right. Okay. So the real question before us is whether we want to make it already make it a class 1 misdemeanor or punishable by both a class 1 and a class 2, I guess, for this exact same behavior. That's the problem. Diggs, you have a problem going by for the day on this. This isn't a finance bill. We can take it up Wednesday. There might be a way to tweak it to maybe accomplish something instead of debating it right now, or not, yeah. Is there nobody wants to do that? Okay. Yeah, bill go by for the day. We'll talk about it on the floor and then see what to do with it. Because It's all right, but I think it's already, I think what you're trying to cover is already a crime, and it's just not the gradient of crime that you're looking for, but we can't muck up the code by having the exact same stuff said twice in two parts of the code. That's a really messy way to mess up our code, so. Okay. All right, thank you, Senator, and thank you for coming today. Perry, why don't you do your bill, and then we'll get to the hard one. What you ought to just do is just amend this other one and say if somebody dies, it's a class one. Germane.
Mr. Chairman and members of the committee, this is Senate Bill 1271, which deals with the threats section of the code, 8260.
Can you make sure you lean into the mic, because I'm not sure it's picking it up. Our mics are all on the fritz today.
Deals with 8260.
There you go.
The threat statute, and it does a couple things. It deals with emails and text messages posted on social media. That deals with the written threats portion of the statute, which I have prosecuted and would have said was the law many, many, many times. I think a written threat is a written threat, regardless of where it occurs, if it's in writing. But I did have a person, she's not my constituent, she would have been Senator Subramanian's constituent in the next district over, who I know
It doesn't have to be
pretty graphically, pretty horrifically, and I have copies of those threats if members want to see them, but I'm not going to distribute them at this point.
Madam, Mr. Chair,
Senator Dees.
I've defended a bunch of these cases, and I've never not had a rule that an email was a written threat.
I completely agree.
I think we need to write the judge a strongly worded letter and tell him he got it wrong.
Well, this is actually not from a judge. This was from a couple Commonwealth attorneys that she solicited who said you can't charge him.
I bet I can guess.
Yeah.
I bet you can't guess. I bet you can't guess, because I was surprised for what that's worth. And, I've seen this a couple times since I've been here in the legislature where I look at it sometimes, say, this is the law, I've done this, I know exactly, blah, 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 and people tell me, no, absolutely not. And so, as far as that's concerned, this is just clarifying, hey, yeah, that counts too. I don't think that should be offensive, because I think that is already the law, and I would concur with that as well.
Where's the Commonwealth attorneys?
Is Vaca here? Nate, come on up. I think Deeds wants to talk to you.
I thought you guys had a training council.
Does Nate prosecute these things?
Good afternoon, Mr. Chairman. My name is Nathan Green.
Should you lean into that mic, because we're not this system's on the fritz today.
Look at, Mr. Chair, I'd ask Nate to look at Senate Bill 1271 and tell us that emails and text messages or posts on social platform are not, do not fit under the definition of electronically transmitted communication in writing.
Mr. Chair.
Go ahead.
I can't speak on behalf of VOC for this, nor can I speak on behalf of the Commonwealth Attorney Service Council, which does our training. But speaking as the Williamsburg prosecutor, if someone came to me and said, I got this email from somebody, we would prosecute.
It's only.
Okay. Sounds like there's some prosecutors that use the law. McDougall, you have a question?
Mr. Chairman, I thought that was, as Senator Perry said, I think it is the law when you said an electronic message in writing. I guess the part that I'd like to talk about more is in Section 2, where we're now adding orally, and then we're adding the person is or could be the object of a threat. Those two seem like much bigger policy changes than listing out the writing. But as far as listing out the writing, Senator Openshade and I was just talking, such as seems like an unusual language choice to list out the writing. I would think you would be included but not limited to might be a better choice if that's what we were going to do, but I think it's law. I do think orally is a big change, though, in Section 2.
That takes it from misdemeanor to felony for an oral threat, right?
I think that's a big, big difference.
Senator Deeds.
I would second Senator McDougall's substitute to
His motion to strike orally.
Strike orally and strike or could be on line 26.
Yeah, Senator Perry.
Okay, it wasn't my position that we had gotten to that portion the bill. I thought we were dealing with the upper portion. If I could comment on the orally, that's specifically as it relates to school shootings, threats to shoot up a school. And I'll tell the members of this committee, I think that's a different issue, and I think it's particularly important. When I was a prosecutor, what would happen is I became the prosecutor who handled threats to shoot up the school. And as many members on this court know, the law treats it differently in Virginia, whether it's an oral threat or a written threat. Some are handled more seriously, some are handled less seriously. Written threats handled very seriously, class 6 felony. Oral threats, not so much. What would happen is we would have people threaten to shoot up the school. They would tell their classmates, I'm going to bring a gun, I'm going to shoot up the school. There's a lot of speech that's protected. As we know, that's a First Amendment issue. That part of this bill deals with if someone threatens to kill someone at a school, to kill or do bodily injury to someone on the grounds of any elementary, middle, or secondary school property. A school bus.
Yeah.
And it deals with, and to Senator McDougall's commentary, it deals with whether the person whether the person who is the object of the threat actually receives the threat or not, and the threat would place or who could place the person who's the object of the threat in reasonable apprehension of death or bodily injury. So that includes if someone says, I'm going to shoot the kids in my physics class tomorrow, that the kids in that physics class could be reasonably in fear of harm because of what is said.
Right. So McDougall has a question.
Also include, though, if a kid said, if you don't stop looking at me, I'm going to kick your knee, that would now be a class 6 felony because that is a threat to do bodily harm.
Mr. Chairman.
Senator, you agree with that?
I don't agree with that.
I don't either.
At all. And it sounds like Senator
Orally
Stewart also
communicate
I don't either.
bodily harm?
No.
How's that not?
If I can, 8260A,
How's that
threat
Hold on.
is described. That is a term of art that is described in case law that has to do with what that means, and it's not simply to kick them or whatever. That's why we don't have written threats.
Mr. Chairman.
Senator Stewart.
But under the statute, as I read it, it's a two-part test. You have to threaten to kill or do bodily injury to a person regarding that person or any member of his family, and the threat places such person in reasonable apprehension of death or bodily injury. So it's more than just, I'm gonna kill you. And somebody says that in jest, it's unreasonable. And so I think she's right. I think it's a...
And for what it's worth, I think there's actually a third part test. The threat to kill or do bodily injury has to be done to someone while they are on the premises of specific places. I think it's a pretty narrowly limited bill that, quite frankly, is aimed at school shootings.
Okay. Well, first of all, I think we need to get this bill in proper statutory terminology. We typically don't use the word such as when we do a list. We use the word, right, we use the words includes or including. Right, counsel? Okay, so Senator Deeds moves and Aird seconds that we, on line 16 and on line 22, we replace such as with including. All those in favor say aye. Aye. Anybody opposed? No. Okay, so that's cleaned up. Any other questions for the patron on this bill that does these two things? Peek, you have a question?
I do not have a question, I have a comment on it.
Because our system's all fritzing out here.
I commend the patron on this, and I was contacted by my sheriff in Bedford County last year or the year before. I thought we tried to bring a bill to fix this, but he had the exact same situation. Somebody threatened to shoot up the school on social media, and they could not do a thing about it. So I like this bill. Thank you.
Okay. Any other, by the way, do you have anybody in support?
I have my, I think I have my constituent who brought.
She online?
I don't know if she's here or not. She's a student at UVA right now.
Okay. We'll set it at 2 and 2 really quick before we do anything else. Anybody in support, come on up or identify yourself online.
Online in support, please raise your hand and put your camera on.
I'm totally fine with that. That's fine.
Okay, it doesn't look like it. Okay, opponents, reset timer, come on up.
Anybody online in opposition? Position, please turn your camera on and raise your hand.
Okay, that's it for the testimony. Any other discussion, any other motions?
Benjamin had a slight change to the, or could be the object of the threat, a slight change to that language to make it, I think, more
All right.
descriptive.
Mr. Benjamin?
That is correct, Mr. Chairman. On line 26, strike the words "or could be" and replace them with "or is included as."
Okay. Senator McDougall moves. Open chain seconds the motion. Any discussion about the motion? Doesn't look like it. All those in favor say aye. Aye. Anybody opposed? No. Okay. Any other discussions about the bill?
Chairman.
Hold on. Go for it.
So looking at 18.2-60, it does say under subsection B, any person who orally makes a threat to kill or to do bodily injury to any employee of elementary, middle school, secondary school, while on a bus, while on school property, at a school-sponsored event, and it continues on. So is this, is this redundant? Is this repetitive? Are we restating the law in a different code section regarding that section?
Sorry, I don't understand your question, Senator.
That the proposition is that the bill addresses the oral threats to a school, but I'm looking at 18.2-60 subsection B. Isn't it addressed there? And maybe that'll be a question for counsel or the patron?
Go ahead, Senator.
I think that's part of the problem. I think that maybe they tried to fix it down there, but those specific threats are made to an employee of the elementary or whatever school, right? Most of the time, these are made not to employees, right? They're made to other people, and so no, it doesn't include. It doesn't include their subsection B says that any employee of any blah 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 blah. Any healthcare provider is subsection 2, and so it runs through it that way, and so this encompasses threats to kill or do bodily injury that are not made to an employee or to a healthcare provider.
Okay, quick follow-up, Mr. Chairman. What about number A2? Any person who communicates a threat in writing, including electronic transmitted communication, to kill or do bodily harm on the grounds or premises of any elementary, middle, or secondary school property, any school event, school bus, regardless of who the, regardless of who the person who's, okay.
Senator Deeds.
Isn't Senator Carol Foy's point, that's duplicative of language in section B?
Senator Deeds.
I mean, I think Senator Carol Foy's point is that the harm in number 2, A2, could also be covered in B. Is that right? Yes. So you have a choice of remedies.
Hold on. Let's slow down. Hold on. Perry, you want to respond, then Peek?
Right, but it's not. Right, that's the whole point. Is that 2 references? B, section B represents you have to make the threat to kill or do bodily injury to an employee of the school, someone who works at the school, or to a healthcare provider. And the vast majority of these types of threats, I'm sure the school are not made to the principal or to the healthcare provider, as that term is defined.
Hey, Senator, hold on. So, but if you threaten an employee, it's a misdemeanor. But if you threaten a student on the playground, it's a felony.
If you write down, "I'm going to shoot up the school tomorrow," it's a felony. If you tell your neighbor sitting next to you, "I'm going to shoot up the school tomorrow," it's maybe at best a class 1 misdemeanor, maybe. But usually you can't prove assault, which is how that would typically fall, and it's not made to an employee.
Okay.
Mr. Chair.
Peek,
So to be totally fair, what you have then, the situation I encountered as a prosecutor, you have kids who can make threats to shoot up the school, and there's not anything you can do about it. It's not an assault. If they're not saying, "I'm going to shoot you," and I have Senator Stewart over here nodding, another former prosecutor, you have nothing.
Is it not a violation of B?
Because it's not made to an employee.
Mr. Chair.
Yeah. Sabrina.
I don't know if my microphone is working. Okay. If I'm reading this correctly, also, besides just the employee, is that one of the sections that Senator Perry's bill is amending also has the language, the threat actually receives the threat, starting on line 26, and the threat would place the person who is, and then we've amended that part, the object of the threat in reasonable apprehension of death or bodily harm, and then they're guilty of a Class 6 felony. In subsection B, there's no such language regarding the reasonable apprehension of bodily harm.
And if I could go back to you.
Okay, Perry, and then I'm going to go to Peak. And we got to wrap this up because we got a big one to do left. Go ahead.
Section B says any person who orally makes a threat to kill or do bodily injury to one, any employee of any elementary, middle, or secondary school while on a school bus, on school property, at a school-sponsored activity. That is specifically if you make a threat to kill or do bodily injury to a teacher. That's essentially what that section is trying to cover. I think we should protect the kids.
Okay, Peak, you still have a question?
Yeah, Mr. Chair. To clarify, B is clearly different than what the senator's addressing in 2A. B only applies on the premises to employees, teachers, janitors, principals. What she is addressing is someone going on social media and threatening to blow up the entire school or go shoot up the entire school. They're clearly different. And if you do it in writing currently, it's a felony, Class 6. And now if you do it on social media or go blabbing it to everybody off school premises, it's a Class 6 felony. I'm sorry that I ever said I supported your bill because I ruined it for you.
Carol Floyd, you're going to move this conversation on.
Sure. So, Mr. Chairman, very quickly, so I think that subsection A2, it does address if a threat to bomb or shoot up a school is made electronically transmitted communication or electronic message to kill or to do bodily harm. It does state that. I think what Senator Perry's bill does add is the oral aspect. So if someone says, I'm going to shoot up a school, it's not covered under 18.2-60, which her bill does. But if they put it in text message or potentially, and I guess her bill also clarifies if they post it on social media as well. So I think those are the two aspects that her bill does cover, the social media piece, which may not be as clear in 18.2-60A2, and the oral threats that is not addressed in that code section.
I think Carol Floyd and Peak have sort of framed it up for us. Senator Perry, I think the word orally might put you in jeopardy. It might not. You might have the votes, you might not. I can't quite tell up here, but if you took the oral out, I think you'd have a unanimous bill. If you leave the oral in, we'll see what happens. You good to go? Okay. All right. All right. So is there a motion?
I'll move to report.
It's been moved and seconded. The bill be reported, referred to finance. No further discussion. We got the amendments done, I thought.
Did we? No, to take oral out.
She said roll. She said she didn't want it. She didn't want it.
I understand that.
All right. Clerk, open the roll.
I don't believe in piling on offenses.
No 7.
Yeah, Senator Obachang.
Move to reconsider the vote by which this failed to report.
Okay, it's been moved and seconded that we reconsider the motion which it failed to report. Clerk will open the roll. Okay, Senator Obachang, another motion.
Yeah. Mr. Chair, I move to strike the word orally.
Second.
It's been moved and seconded we strike the word orally from the bill. All those in favor?
Aye.
Aye.
Aye. Anybody opposed? No.
Move to report.
Okay, it's been moved and seconded. The bill be reported, referred to finance. Clerk will open the roll.
There's one.
Okay, bill reports refers to finance. Okay, the last bill we need to take up is the fentanyl murder bills. We got two bills in front of us here. We have McDougal and we have D-Steph. D-Steph, I believe, has agreed to be rolled into McDougal. Is that right?
Sure, I'm fine to do that.
Okay, you want to speak before we roll you?
The difference between the two bills are basically, we added synthetics. Synthetics seem to be a major problem, so maybe we can include that. And then the Office of the Chief Medical Examiner wanted to be able to substitute on this, harvest the organs regardless. So maybe we can include that. Or not.
Okay, I guess we're going to see where this goes. Senator McDougal. McDougal, I've given you a substitute. Have you had a chance to look at it? I did. Okay, what do you want to do?
So, Mr. Chairman, just to make sure we understand what the issue is.
Well, just so we have it before us, why don't we get the sub up and online so we can have it in front of them so they all know what we're talking about? Okay. Counsel, can you distribute the substitute? So Deeds will move and Aird will second the substitute for purposes of having a discussion about the substitute. Yeah, I have a copy. So substitute is being handed out. You can post it online.
You might want to board it still is referencing.
Yeah, MJ, can we get the board updated? And put in McDougal's bill. We'll get back to D-Steps in a second.
Mr. Chairman, just to make sure the members of the committee understand where we are. Right now, the law prior to 2014, if somebody sold a drug to another person, that person died as a result of taking that drug, then they can be convicted of felony homicide. 2014, there was a Woodard case that was versus Commonwealth that said that the person selling the drug had to be in physical proximity of the person taking the drug when they died. So the solution that we came up with in this bill, so it created two problems. One, if a person is in physical proximity, you can convict them, you could also convict them of distribution. Right now what happens is somebody sells the drug, fentanyl or heroin, the person, when they buy it, does not use it where the drug dealer is. They go somewhere else and use it, and then they die. Under the Woodard case, you cannot be convicted of distribution resulting in felony homicide, and as a practical matter, it is almost impossible to convict you of distribution because the person that bought the drug is now dead and can't testify, and you couldn't establish whether the drug was purchased in the jurisdiction where they died, can't establish where they used the drug, so the person distributing it is not convicted for that death, distribution, or homicide. So what we tried to do in the language that I originally introduced is said, well, one other thing. The current law today, though, says if you are using drugs and you give it to your friend that sits next to you, you use it together, and your friend dies, you can be prosecuted for that homicide. So the person that sold it to you cannot be prosecuted, but if you gave it to your friend, you can be prosecuted. That is the law today. If we don't make any changes, that'll be the law on July 1. So what we tried to do is say the person that's giving the drugs to their friend is not as culpable, not as responsible, so they should not be convicted of felony homicide. We reduced that penalty of what they could be convicted of and said that if you sell the drug and the person uses it, regardless of where you are physically, then you would be convicted of felony homicide. What the substitute does is doesn't say that, takes what says that if you're a minor and you distribute and you die as a result of fentanyl, then that can be felony homicide. So, but Mr. Chairman, my concern about this is today, if if the drug dealer sells heroin or fentanyl to an adult and they're in proximity, they can be charged. I'm afraid the way this is written, it would eliminate the ability of that dealer to be charged with the homicide if they are in physical proximity. So take something away that could be charged today.
Could counsel, Mr. Benjamin, can you answer that for me? Like, the subsection B is strictly limited to fentanyl. So how would that mean that it would take away any existing law on heroin when it doesn't address the existing statute?
It would not, as I understand it.
Okay. It just means that this new concept of distribution to a minor wouldn't apply to heroin. But the existing law still stays the same on heroin.
Existing law would stay the same with heroin, correct?
Right. Okay.
Mr. Chairman.
Yeah, Senator McDougal.
And of course, I appreciate you giving it to me, but it's only been 30 minutes. But Section B on line 16 says, if the Felonious Act resulted in the killing of a minor and involving the distribution of fentanyl. So is the way that you read that, and Mr. Benjamin says, if it's adult in fentanyl,
Existing law applies. Whatever that is, the existing problem you're trying to fix still exists. This addresses the fentanyl problem that you've identified, but only as it relates to minors.
It's only changes the law with respect to the death of a minor.
Right.
and fentanyl.
Yeah.
But not a minor.
Correct.
And so, Mr. Chairman, then it's going to become a matter of proof of if the fentanyl was mixed in with some other drug, whether it was the fentanyl exclusively that caused the proximate death, or whether it was the heroin and fentanyl combined that caused.
You got it. That's right. That's right.
And Mr. Chairman, it does not fix the, I guess looking at lines 29 through 34, if a person distributes or fentanyl as an accommodation, then their penalty would be reduced. But if it's fentanyl and heroin, then they would still, and they give it to their friend, then they're still would be convicted of the felony homicide.
If they could otherwise meet the terms of subsection A.
Yeah, Mr. Chairman. But I guess subsection D is trying to reduce the penalty on individuals that are providing drug as accommodation. In other words, two users together. I mean, when we say accommodation, we really mean two individuals that are using together, not as somebody that's dealing or making a profit off of that sale.
Right, somebody's not making a profit, right.
So the way this is written, it would only be if it was fentanyl, not if it was heroin. Or
Correct.
so fentanyl
Correct.
could be in some other substance. But if that's not the only substance, then you wouldn't get that benefit. Is that true?
Mr. Chairman. Senator McDougal, I think that accommodation applies to distribution. And so I think that I think under your hypothesis, right, I think if it were some mixture of heroin and fentanyl and it was distributed to someone, I mean, that person would still have, I think, I'll call it the defense or the mitigating factors of accommodation would still kick in.
Mr. Chairman, I guess it's section D. It is right now under section A. If you distribute heroin or fentanyl to an adult, sell it so they make a profit, then and you're physically in proximity, you can be convicted under A. Correct. Section D is now saying that if you prove that you distributed fentanyl as an accommodation, then you're guilty of a class 5 penalty, a lesser penalty. And my question is, if it's fentanyl and heroin and you die, you still under A?
I think the answer is you're still under A, but I think accommodation would still kick in, is what I'm saying.
What, Mr. Chairman, but the way I originally wrote it is if the death, regardless of what the substance was, if it was accommodation, then it would be the lesser penalty. So if it's fentanyl, if it was cocaine, if it's something I don't know of right now today, then that would be an accommodation. If it's by accommodation, lesser penalty. The way this is written is only if it's fentanyl, if it's a lesser penalty. If it's another substance, it's not the lesser penalty if you're in proximity. So the two users together, if they're using straight heroin, they're next to each other, even as an accommodation, it is felony homicide.
Sorry, I think it's ambiguous at worst, but yeah.
I don't think so. I think that if you are sitting next to someone and you distribute a controlled substance to them, accommodation kicks in. And so you are subject to that lesser penalty if you can prove your accommodation defense. Hold on, let me finish. Hold on.
I don't think we're talking about the same thing. You're right for distribution. For the homicide and the death, under the current law, that's not the current law. Current law is that if you're in proximity, even as accommodation, it's the...
Unless you're trying to charge them with distribution because they're in proximity. Is that what you're getting at, Perry, or no?
Two separate charges, distribution and felony homicide. Senator Perry's 100% accurate on distribution. On felony homicide, accommodation, next to each other, death, gets you felony homicide.
Okay, any other questions about the substitute? Carol Foy?
Quick question for the patron. One of the questions I have, and I know we're discussing a number of things, but I also have an issue with 23 through 25, lines 23 through 25 for venue. Typically, we say that the proper venue is a place where the crime occurred. So if it's distribution, then it's where the transaction happened. If it's a death, it's where the death occurred. And this is opening up multiple avenues for venue. And I just wanted to hear the patron's response to that.
Mr. Chairman, this was language that I was given. I didn't come up with any of this new. But I would say the issue with venue, I have a separate bill.
I think that section came out of your bill.
Right, so I have a separate bill that does the same thing. The issue comes if somebody dies, the ability, and they go into arrest, they're taken to the hospital, the ability to prove where they died or whether the substance was distributed becomes almost impossible. Because if the person dies at the hospital, you know that they've died there, you can establish that, but you can't establish that, or it's difficult to establish that they were given drugs at a separate location because they're now dead and can't testify. And so this was we do that in other situations where you might have a fatality, you can prove it at the place where they passed, which would be the medical facility.
Mr. Chairman.
Carol Foy.
Quick response. I guess the distribution is pretty clear at the time to figure out the transaction happened. But for even deaths when they dump the body in a different location, I mean, typically it's where the body is found unless otherwise information comes forth that they died somewhere else. We just use that venue. So I'm just worried about opening up multiple lanes of venue in this code section. I think it's because this is a felony homicide bill, it's homicide, it should be where the death occurred, and whatever evidence goes towards where that death may have occurred, and not just where the drugs were sold.
Mr. Chairman, I'm probably okay with where the death occurred. That seems to be the challenge right now, is you're having to establish where the drugs were distributed. If it's where the death occurred, Mr. Green, sure that he agrees with me on that.
Okay, so you would want to strike where the use of the controlled substance occurred?
I just want to be clear about that. If we limit the venue, I'm sorry, Mr. Chairman. Go ahead. If we limit the venue in that way, if I distribute drugs to my seatmate here and then I take her body over to across the river into Maryland, right? We just have removed venue from Virginia altogether.
It's true.
Is that what we're really seeking to do with this bill?
That's a good question.
That's why we have the, I think.
When you have, Mr. Chairman,
Senator Carol Boyd.
but when you have that hypothetical, no matter what type of homicide occurred,
No, the answer is no. I prosecuted, I think it was a cold case homicide, and we weren't sure where the victim was killed. We couldn't find her body. It was a no body case. So where do you prosecute it, right? There are specific venue prosecutions in Virginia that deal with a number of things. I'm looking at 19.247 venue in certain homicide cases. It says where evidence exists that a homicide has been committed either within or without the Commonwealth under circumstances that make it known where such crime was committed, the homicide and any related offenses shall be amenable to prosecution in the courts of the city or county where the body or any part thereof of the victim may be found, or if the victim was removed from the Commonwealth for medical treatment prior to death and died outside the Commonwealth, or in the courts of the county or the city from which the victim was removed for medical treatment, as if the offense had been committed, blah, 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 and a prosecution, blah, 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 the offense may be prosecuted in any jurisdiction in the Commonwealth for which any one of the killings may be prosecuted. My point is there are a number of venue, I'm sorry, I think Senator Deeds is gonna.
Mr. Chair, I was just saying, why don't we just refer to that code section? Instead of trying to do something brand new, just refer to that code section, then use pursuant to that code section where other homicides are going to occur.
If I could look at this, and I apologize, I didn't prepare for this exact argument because it included broader than that. But I'm not even certain that one is the one that would fix it. I would have to spend some time looking at it. But there probably is one that would fix it. I'm not sure it's that one.
Senator Deeds.
My point is provide a fix. If this bill is going to go forward, it's got to go through finance. And so if you can provide a fix now, we do more research and determine more fixes needed. If the bill's going to advance, we're going to have opportunities to make those fixes.
Right, and I'll just point to the page 244 deals also with venue in general. So I think there may be a couple different things. We can talk about it offline. I know we're at a shortage of time.
Okay. Mr. Chairman.
Yeah, McDougall.
Just to point out, we do credit card theft prosecutions the same way. It's where it's either in the jurisdiction where it occurred or whether it's discovered. So this is pretty much the same language as that.
Okay, so McDougall, just to move this along, because it's now 11:37. You have a sub before you. My suspicion, although I don't know, is that you might, if you accept the sub, you might have a vehicle. If you don't accept the sub, not sure you're going to get anything.
Mr. Chairman, first one technical correction on line 19, after the word person, insert who is a minor.
Okay, Senator Deeds moves, and Aird seconds that we add who is a minor, line 19 after person. All those in favor say aye.
Aye.
Aye. Anybody opposed? No. Okay, that's just clarifying. Is another one? Where's that?
Line 29, remove one and or.
Sorry, where is that, Ms. Fry?
Section D. Remove Roman numeral 1 versus and or.
That's correct. Okay, Deeds moves, and Aird seconds. We strike Schedule 1, the Roman numeral I, and the word or on line 29. All those in favor say aye. Aye. Anybody opposed? No. Okay. So, because fentanyl is not a Schedule 1 drug. So, McDougall, you want the sub or not? For the time being. I know you don't like it, but you want to live or you want to roll the dice? Yeah. Yeah. I got it. And I'm happy to take their testimony. I just wanted to get us in a correct procedural posture before we take testimony.
Mr. Chairman, maybe you could hear from some of those family members before you take a vote on the sub.
That's fine. And we have to deal with D-Step still too. So why don't we set the timer at, just do 5 minutes, anything?
So online and support, please raise your hand and turn your camera on.
Hi, thank you so much for taking our testimony.
So really quick, so everybody's clear, we have to set the timer at 3 and 3, and I would love to set it for more, but we have to be on the floor in 22 minutes, so, okay.
I have a group called Fentanyl Moms, and we family members who have lost someone to fentanyl. We represent thousands of families across Virginia who have lost someone. You all are well aware of the problem with fentanyl. Since last year, about this time, we've lost about 1,800 more young Virginians, many from one counterfeit pill. And we are hitting it with everything: recovery awareness, we've got revived training, and we actually have reduced the deaths a little bit, but this is still a very important component. I think one of the problems with this, with fentanyl deaths, it's difficult to prove proximity, that the person that sold the drug was actually the one that caused the death, because we're not usually looking at, we're looking at few dealers that are killing many people, traffickers. So that's what we really are looking for. This committee says that possession and distribution can already be charged and sentenced to 5 to 10 years. In the case of the dealer responsible for my niece's death, she was only 18. He served only 4 months and has been caught multiple times selling back in and then out again. Since 2018, in the impact statement for this bill, it states that greater than 13,000 people have died from fentanyl, and only 110 have been prosecuted related to a death from fentanyl. 13,000, only 110 have been charged. So we're only talking about the traffickers who are responsible for multiple deaths. I do believe felony homicide is a deterrent to dealers and traffickers. And when you all brought up the cell phone issue, cell phone records are also very important for fentanyl deaths, because most of these families that are present here, they were not able to retrieve cell phone records that proves the social media sale of the drug. And, I was happy to see that many of you are supportive of traffickers being held, someone who carelessly looks at their cell phone and causes a death. Yes, that's a huge problem nowadays, but we also have people purposely selling drugs, selling fentanyl, and causing deaths. So I think that we would really ask that you support this bill and consider moving it forward. And we obviously have some families here to testify.
Okay, thank you. Come on up.
Watson, and my son's Troy Howlett. He was an adult, so I'm in support of this bill for minors and adults. We need to pass this bill. My son's dealer is still out there. He sold my son a pill that was supposed to be Percocet, but it was straight fentanyl. He's still dealing today. He's never been charged. This bill is near and dear to my heart. This could be your son, and I'm in support of the bill.
Thank you. We have 15 seconds coming up.
This is my son, Keen Harper. He died in his bedroom. I was upstairs in the living room, and he died right beneath me. The coroner said it took 3 seconds for him to die. It was fentanyl in his system as well. He did not buy the pill. It was given to him by a friend. I want this bill passed. We're not out to lock everybody up, but we want you guys to go after the big cahoots. I'm sick and tired of coming here. This is my 3rd year. I'm traumatized as it is by finding my dead son in the manner in which I found him. And if you could walk in my shoes, some days I could care less if I freaking wake up. And I think most of us families feel this way. And I pray to God none of you have to go through what we have gone through, because it is awful, awful.
Okay, thank you.
That's fine.
Sorry, say who you are and say you support the bill.
Jennifer Johnson. I addressed you last year and told you the story of my son PJ and his girlfriend Anna, who were 19, purchased a Percocet at an open mic night up by GMU in Fairfax County, came home to our home in Stafford County. I found them dead in the basement the next morning. My son was 19. His girlfriend had just turned 19 that weekend before. They were minors, or not minors, so I'm in support of this for minors, obviously, and adults. I don't know what else any of us could say. We come to you, we beg you. There's thousands more families since this has started. I guess we keep coming and we keep doing this, and maybe someday some family will get justice.
Okay, thank you. Come on, just say your name and that you support the bill.
Ezra, I'm in support of the bill.
Thank you, Ezra. Come on up.
Hi, my name is Lisa Reed. My daughter Caitlin was 23 when she died,
thinking that she was getting something else during COVID. I just want to say this. We've all been here, we're reopening wounds that we're trying desperately to heal. And when we come here, it's like pouring salt on it. We need you guys to do your job. Protect these kids. You can't protect our kids anymore, but there are thousands and thousands of kids that you can protect. Please do something about this.
Okay, thank you. Sheriff support? Okay, thank you. Okay. Is there one more? Okay. Your name and that you support the bill?
McCallum. That's my son, Brendan. He was given fentanyl, xylazine, carfentanil, and it was supposed to be Percocet. My son paid for his mistake with his life. And the dealer is still out there. I fully support the homicide charge.
Okay, thank you.
It's kind of insulting that when we first started giving our stories, most of you weren't even listening.
Okay, thank you. Okay, next up. Okay, that's it. Okay, reset the clock. Opposed, come on up. 3 minutes.
Any attendees online in opposition, raise your hand and put your camera on.
Brad Haywood with Justice Forward, Virginia. If we cannot destroy the drug menace, it will surely destroy us. We must further tighten the noose around the necks of drug peddlers and thereby loosen the noose around the necks of users. We are seeking severe punishments against drug pushers, but more lenient sanctions for users. Although it's too soon to assess the effect of the new penalty structure, I expect it to help deter or remove from our midst those who traffic in narcotics or other dangerous drugs. Those words are obviously not mine. They're Richard Nixon's, offered 54 years ago when he first announced the war on drugs. He believed, as the bill patrons do, that we could incarcerate our way out of a public health problem. We can't. We know that because Virginia, in response to Nixon's call, passed the current penalty structure, which is 5 to 40 years in prison for distribution of any amount, with significantly enhanced penalties for second and third offenses, for the quantity, for profits earned from dealing, and as of 2 years ago, for a tack-on fentanyl weapon of terrorism charge that increases the penalty range above that of felony murder. None of it has helped, and these bills won't help either. Similar homicide laws exist in other states and have done nothing to curb dealing, use, or overdoses. Moreover, they may increase fatalities by dissuading persons witnessing an overdose from calling 911. Ultimately, these bills are performance masquerading as policy. This is not a game. Real lives are at stake. The war on drugs has failed. An evidence-based, public health-oriented approach, not a fear-mongering, vote-garnering approach, is what we need. We oppose this bill.
Is there anybody else opposed to the bill? Is anybody online opposed to the bill? Doesn't look like it. Okay. All right. So we have a sub before us. First of all, I just want to say to the people who testified, we appreciate you coming. I know I met with many of you. I'm not sure if any of you out there, but I've met with many of you and fentanyl victims' parents in my offices over the last 3 years. I don't think anybody up here questions what this scourge has done in our country in terms of all the people who have been killed, who even had no idea they were ingesting fentanyl and ended up dying. The issue that's before us is what's the correct response in terms of the criminal justice system. And I think there's a concern, has been a concern in this committee since these bills have come forward, that adding another felony on top of 2 or 3 other felonies isn't going to solve the problem. Although I think Senator McDougal would say to me that there is a subset of situations where those other felonies might not apply, which is why this statute is needed to fill the gap. And so what we've done here is we have a substitute before us, which applies to a subset of what Senator McDougal is trying to go after, and that creates a vehicle by which we can continue to have conversation over the rest of the session instead of ending the discussion today in this committee. And so that vehicle is before you. If you want to accept it, if you don't, we can.
Can I point out one on line 26? It talks about, we did not talk about this paragraph. It says no person subject to prosecution. Could that be no person convicted? Because the issue will become the way that this substitute is drafted, a battle of experts about whether the fentanyl alone was the proximate cause. The jury could decide that the person died because of fentanyl and heroin. What do you think? And then you cannot prosecute the individual for distribution. And this will make, that pretty much makes the choice for the government to have to be to only prosecute on that. So if you said convicted, then that would mean that you couldn't prosecute, somebody couldn't be convicted of both, but it would take. Is that right? Mr. Benjamin agrees with me.
So we treat it like we do DUI and reckless, and like right now, instead of deal with it on the front end.
Well, I'll say I think it makes sense, and I think it makes sense for this purpose. You when you say prosecution is generally commenced by a charging document, and at the time that you have to pick a charge, you may not know what it is. I guess the outcome of it would probably be you mitigate in favor of just distribution and change that later. I think that's how that would work, but I understand Senator McDougal's point.
So I guess the way we'd fix that is we would strike subject to prosecution pursuant to and replace it with shall be convicted of. Okay, peak moves. Well, actually, we don't have the sub before us yet because we haven't adopted it. We haven't adopted the sub yet.
You're going to adopt the sub.
Well, I'm leaving it up to you as to whether you want the sub.
Bill?
I think you'll have a much better chance on the regular bill if the sub is adopted. And,
I don't love the sub, but I'll live to fight another day.
okay, sub's been moved. All those in favor of the sub, say aye. Aye. Anybody opposed? No. Okay. Now, Peak moves. Stewart or somebody. Stanley seconds that we strike the subject to prosecution pursuant to replace with shall be convicted of. All those in favor say aye. Aye. Anybody opposed? No. Yeah, the venue issue is still lurking. I'm not sure we have a solution to that right now. But we now have a substitute before us. We've taken testimony. The bill does need to go to finance. Do we have any other discussion? On what? Hold on. What, MJ? Okay, yeah, I'm sorry. D-Staff, do you want to be a hitchhiker or do you want to live or die on your own?
I know what's going to happen if I push my bill forward. Clearly, it's not going to go forward.
You want some credit?
Honestly, I'm not here for credit. I'm here for justice.
Okay.
And I feel that
All right, hold on. We got to keep this moving, folks.
what we've done here is we've now said, well, we're going to give you a lesser offense for heroin, and we know that heroin and fentanyl are mixed. So, I've had this less time than Ryan's had it, and I still want to read this, but I'll roll into Ryan's and then just comment from there.
Okay, so Senator Stewart moves, Stanley seconds, the D-Staff be rolled in, incorporated, both be listed as chief patrons. Can you open the roll, please? Okay, now you're incorporated. Okay, now we have a bill before us. I don't think there's anything else to do procedurally. Any other motions?
Comment on the bill. There were some comments made about whether this bill is going to solve the drug problem. Well, clearly, we're not going to solve the drug problem, but we have laws to punish people who violate the laws. And these people are out there killing our citizens, and they need to be punished. And there's crime and there's punishment. It's not all about rehabilitation. There's crime and punishment. This is punishment for killing our citizens. I move that we pass the bill.
Mr. Chairman?
Stanley, go ahead.
Just to add, I'm a criminal defense attorney. Among the other things I represent in civil cases, criminal defense cases. And let me tell you something. They're smart enough to know, and this is a deterrence. I've had many that knew when we relaxed the law on shoplifting, that increased and encouraged. They know when we get tough on things, that it acts on as a deterrence. And I think this is a great deterrence. And it's a good statement for the policy of the Commonwealth of Virginia, but ultimately, then we're putting away these murderers and putting them where they should be for doing this to these families and these children. Thank you, Mr. Chairman.
I just want to mention, there's also a version on the House side which takes a whole different tack at this. I'm not sure whether we're going to see it or not, but it's a very different approach than what this one is. At least there'll be a Senate vehicle to talk about if this proceeds, and maybe there'll be a House vehicle, maybe there won't. We'll see. But probably a discussion for the next 30 days. So appreciate everybody coming today. We've been hearing about this for a while now. We're going to continue to hear about it, even if we pass this bill or any bill, probably. But it's a big problem in this country, and we're doing what we can. So we have a motion to report and refer to finance. Any other discussion? Okay, clerk will open the roll.
Ayes 13, noes 1.
Okay, bill reports refers to finance. Senator Stewart.
Chairman, having voted on the prevailing side by which Senate Bill 1012 failed to report, I'd move we reconsider that bill.
Senator Stewart moves, Deed seconds that we reconsider the vote by which Senate Bill 1012 tied on a 7-7 vote. Clerk will open the roll.
Mr. Chairman, I'd move that that bill be reported.
Okay, Stewart moves, Deed seconds that the bill be reported and re-referred to finance. Clerk will open the roll.
This is your
No 7. Can't do it. What's that? Yeah, the first time?
Yes.
The Senate of Virginia, Richmond, Virginia.